With your lordships nominal under the statutory scheme, there is no appeal from that under 37 of the arbitration. According to me, the only option is to go under 136. But there are cases where lordships have come a few exceptions where the repetition is maintainable. Where your lordships have said that in exceptional cases, extreme rarity, in those cases, the repetition is maintainable, but otherwise it is not maintainable. Now you cannot go to the.
I think we had an occasion to decide one matter.
I have found out two judgments of this on the day. One is MPC projects.
This is no.
Taking the point that the
no, demo was taken in the single bench.
Not in the. I will be very honest. Not in the that I am taking. In view of deep industries judgment, which your lordships have considered in NPC project, and judgments of the Supreme Court which carves out a very few exceptions, but those are under 20. But I have tried to find out the way your lordship's roster is placed, which on the day this matter was moved before the single judge, the roster said that writ petitions under the arbitration, serial number 12 of the roster. Now, the writ petition can be, as I find over here, it can be both under 226 or 227. Whereas the applications under 227 of some other learned judges, I have found. Therefore, the basic point would be that whether against a judicial order.
Where is the judgment of the single bench?
Yes. Judgment of the single bench, the lordships would find from page 50 to 5. It's
page 55, a lot of the writ appeal set. Running page 55.
But I dilate later on, your lordships, it's a lengthy judgment. Kindly take the 16th page of the judgment, para 28.
I see that para 66, Leonard Single Judge has formulated one question.
Yes, Miller.
Para 66.
Right, Miller. Legality, Miller, and binding effect of the Supreme Court's order.
That's it. That's
Miller, please take my paragraph number 24, page 13. My lords have found that. Para 24 at Miller, running page 67.
Just 1 minute. You must have read it. I have not. So just give me some time to do. Paragraph 24.
Yes, sir.
Arbitration and cancellation.
That was an interim order of stay that was granted, which was challenged in 2026. Now, after the argument having brought,
yes,
I think in 2015 probably.
Yes.
Now, initially it was the moment the the 34 application is filed, immediately automatic stay of the execution.
Right.
But later on, there has because of Justice Nariman's judgment, I think associate builders or associate whatever. So that was there that led the the amendment to be brought. And now the stay has to be specifically asked for. Otherwise, it will not conform to a.
Right.
This is the order where the stay has
Been granted in favor
with a full monetary security.
Yes, the full monetary security in respect of the main
Section 34 is pending.
34 minutes.
Okay. This is really in the form of an order 41 rule 5.
Right. Right. The stay is granted on certain conditions.
Their petition must have been under clause B.
Correct. Correct. 36 1B, my lord's absolutely right.
Yes.
And identical issue from Calcutta has been decided by the Supreme Court against them on a concession, and therefore that is followed here. Whenever our turn comes, we'll certainly.
But that is a petition order is not a ratio which has to be done.
Concession because it is fraud. They admitted fraud and they avoided a finding. I'll come to that. I'll come to that.
So what the court has held, that is
The court has granted an
is a
objection
prima
to
facie hold, that's it is an outcome of a fraud.
the court, in my very humble submission, did not come to any conclusive finding. On the other hand, the court says that pleading and evidence needed to be looked into to ascertain fraud, which your lordship will find for paragraph 58 of the judgment. Please take note of internal page 32, running page 86. May I please take note? Therefore, the exercise of jurisdiction under section 36(3) necessarily obliges the court to apply the pleadings and record to ascertain whether the challenge raises a prima facie case of fraud affecting the arbitration agreement or the award. Only upon no prima facie case exists can the court proceed to consider proportional conditions for stay, including deposit and guarantee. If however the court omits this mandatory evaluative step and straightaway directs full security, it is not only disregards the statutory command of unconditional stay in fraud cases, fails to exercise in the jurisdiction in the manner prescribed by law, rendering the stay vulnerable to supervisory correction. This court also notes that the petitioner had relied upon the order of the Calcutta High Court dated 8/8/2020. Justice Sarab's judgment.
Upheld by the division.
Yes. Now, may I tell you a few things. Number one, Millard, in the 36 application, there is no pleading of fraud. This is very, very important. Fraud, as your lordships have always said.
Particulars of fraud is to be pleaded under the court.
So,
Order 7 rule fraud.
So this is my first point. Neither pleading, the question of proving doesn't come. Because the pleaded case is not that of a fraud, number one. Number two, Millard, where a unique argument with respect to my learned friend has been advanced, is that because in another arbitration award stemming from the same agreement but by a different tribunal, Millard, the Honorable Supreme Court, on concession of parties, Millard had appointed an arbitrator. Award is bad. Number two. Number three, Millard, that
Same arbitrator.
no, completely different tribunal. Number three is, Millard, under 36, the court cannot be invited to replace arbitrator. So if under 36, the court cannot be invited to replace an arbitrator, so therefore the question of Millard looking into a Supreme Court judgment where Millard consent, Millard orders have been passed replacing the judgment, the honorable tribunal, But I don't think that has got any
What the
prescription.
single bench has done.
No.
Single bench concentrated on a unconditional stay,
Yes. Single
not
bench.
replace arbitrator.
Not. It only said go back, there is an uncut. Now it has amended the order.
The
and
single bench couldn't have done so, but that is rightly done. Now, please take me up the paragraph number 73, running page 96.
The order of the commercial court is set aside.
Yes.
Arbitral award shall remain stayed unconditionally.
Yes.
And
And commercial court,
court was directed to dispose of IA.
IA 151, where is the scope of CPC application in a section 36 proceeding? But the Lordship also will.
Why not?
I'll tell you, Lordship, why not? You're under the, unlike the 1940 Act, arbitration, in the 1940 Act, you had made the entire CPC application.
No, that's true, because it has made rule of the court.
Yes.
The award itself is simply a paper
Yes.
under 1940, unless it has made rule of. So one has to approach
Yes.
and then make it. Here, there's a very unique, the mechanism that has been now framed by the legislatures is
Yes.
that take character of decree. Now the question arises that when the definition of a court is given in the original constitution, and then so far as the section 34 is concerned, section 9 is concerned, those are to be done by the court. Once the approach is made to the court, then the question that arises that what procedural law will apply to the court in those proceedings. I know there is a prohibition of applicability of the Evidence Act as well as the Code of Civil Procedure under the Arbitration Act, so far as the arbitral tribunal is concerned.
Right.
But the moment the approach is made to the court, then why not the procedure which is normally followed court in all the litigations, that would not be followed.
I'll tell you, Lordship, why.
Why I'm telling you, because there was a use.
Yes.
I may lay hand to it to that extent. In Calcutta, that some miscellaneous appeals are required to be admitted under Order 41 Rule 11.
Yes.
This Section 37 applications or appeal, then the question arose whether it requires an admission under Order 41 Rule 11 of the court.
Right.
Chapter 6 Rule 17 or Chapter 5 Rule 17 of the Appellate Side Rules that says that certain categories of the appeals which can be directly registered, and impliedly apart from those are required to be admitted to Order 41 Rule 11.
Right.
A point was taken that there were two rosters which was given. One, Section 37 to one division bench, and Order 41 Rule 11 to another division bench. So when it came for the Section 37, the roster, the question arose whether it requires an admission. I think the three-judge bench of our High Court has admitted that no, anything which goes out of the purview of Chapter 5 Rule 11 requires an admission under Order 41 Rule 11, not automatic appeal, like a first appeal under Section 96, where no admission is required, it has to be registered, has to be heard. So in those scenarios, if the Code of Civil Procedure is made applicable and an admission is inevitable, then why not the other provisions may not be lock, stock and barrel, but mutatis mutandis, the principles akin to, why not those would be embraced by the court? I think two Supreme Court judgments are also there, I think on that ground. Why I say I lay hand, because when I was on that side of the room, I raised this plea before the division bench. And the division bench agreed with my proposition and says, no, it requires an admission under Order 4111. The division bench of Justice D.K. Seth and
Justice Pal possible.
That we have a,
that is my personal experience on that.
Now,
we have a bad issue in Supreme Court, my lord, like this. When the Article 136 is always discretionary, there are many tribunals against which orders are statutorily appealable to the Supreme Court. Question arose because it's a statutory appeal governed by a statute to the Supreme Court directly. The admission is automatic. Supreme Court said, no, we'll have to hear you because any admission is discretionary.
No, there are many aspects in the original side of the Calcutta High Court, the clause 13 application, where the original side of the Calcutta High Court is vested with the power to withdraw any of the suits from the the district courts, subordinate courts. I don't use the word subordinate, I say the district courts. That's why. Now, glossary of those, though it is there in the Constitution itself, but still. So it's a district court, he can try his own suit. That order transferring the suit from a district court to original side of the High Court final disposal is not applicable under clause 15 of the latest patent. So the appeal provision was not there. And in the original side, there is no provision for a revision like 115 because it does not lie, or 27. It does not lie. So directly, it has to be appealed before the Supreme Court. So I think Kim Ji's judgment of the Supreme Court is, I think, is a parent judgment on that. If I correctly remember. Babulam Kim Ji's case. So there it has said that it has to go straight away to a Supreme Court. Yet it requires a leave under Article 136 of the Constitution. Automatic appeal is not there. So that has to be done. Otherwise,
well, may I say this, Milord? In the context of the Arbitration Act, please consider whether the CPC whole hog will apply. Why I say this? But under the 1940 Act, there was possibly section 41A or B. I don't remember.
that was an interim order, like Section 9.
Yes. No, I'm talking about
41 Old Act. That 41 Old Act is akin to Section 9 of the Act because interim order, I think in 41, if I correctly remember.
Yes. But I don't have the old act now. Now, in the old act, there was a specific provision which said that the CPC.
That's true. There is no doubt about it.
So, the legislature prescribed in the 1940 Act the applicability of the entire CPC. Now, when the 1996 Act comes, the 1996 Act contain a similar provision where the entire CPC is applicable. Now, we need to trace out from the 1996 Act that the CPC has truncated application insofar as 96 Act is concerned. Now, take an example. Please have a look to section. Lordships have had a look, Milord, several times.
Arbitration and Cancellation Act.
Just as an example, the 36, since we are on the dialing of the matter related to section 36.
Yes. Yes.
For example, take the first subsection,
Yes.
where the time for making an application to set aside the arbitral award under section 34 has expired. Then, subject to the provisions of subsection 2, the award shall be enforced in accordance with the provisions of the civil procedure in the manner as if it was a decree of the court.
True.
So it becomes a deemed decree of the court. Well, one of
Then automatically Order 21 comes into play with lock, stock and barrel. The supplementary part from section 36 onwards till 74 or 73, if I correctly remember, of the CPC. Those are attracted.
So incorporation by reference. Now please take, Milord, subsection 2. Or if I come to subsection 3, the first proviso.
Yes.
Provided that the court, while considering the application for grant of stay in the case of an arbitral award for payment of money, have due regard to conditions of grant of stay of a money decree under the CPC. Only order 41 rule 15 read with order 41 rule 5. So here we learned, subject to correction by your this is where we learned the CPC has a truncated application over here.
True.
So if it is a money decree, money award, then apply those principles. Again, Miller, your lordships have also held that you need to draw inspiration from the CPC. These are not applicable. The Supreme Court has said first in time, then there are following judgments also. Therefore, Miller, be that as it may be, in an appropriate case where we can direct on this. 151 applications prayers. Please have a look to page 468. First prayer is set aside the arbitral award on the preliminary ground that the Supreme Court has set aside a similar award under the investment scheme, so and so. First is whether this kind of a prayer is maintainable or not, because it's under 34. This prayer is already there in the section 34 application. Then can you get the therefore the dispute covered under impugned award for adjudication by Honorable Justice Spencer. 151 is not meant for this. Either it has to be under section 11 or under section 50. 151 the CPC, then pass such orders. Therefore, the 151 application, well, in fact, I hope my friend will confirm me, when we were arguing the matter before the commercial court, I made a submission before the court saying that my learned friend was not there. I made a submission before the court that he must make a choice. Which of the applications he wants to move, 34, 36 or 151? He opted for 36 only. That was quite justified. Therefore, the 151 application, irrespective of its applicability, let us keep it aside for the time being. But these prayers are not. Now, the learned single judge directs that on the 151 application to be heard today. I could understand that the learned single judge directing the 34 to be heard. To arbitration or to an arbitrator has to follow the interplay of section 21, then section 11, and if an occasion arises under 15. There is no other provision. Neither can the commercial court do, nor the court can pass such a direction. Therefore, we come back to the original point or proposition.
The direction was only to hear out that IA application, that is 151 application. But it's possible.
Unconditionally state.
That is a different. That is one of the different point. As 151, the court cannot opine that you allow the 151 application.
Right.
You have every right to test that application, including a point that it is not maintainable or the prayer which has been made that is not covered under 151. It cannot. These points can be agitated before the commercial court, and commercial court, in its wisdom, has to decide the matter. It may allow, it may reject, whatever. There's a left the commercial to decide on that point. So I think mere direction to dispose of the application does not really, I would say, causes any prejudice to you in that way, because ultimately, whenever any application is filed, it has to be decided.
But at the same time, the award is unconditional.
Correct. Now the question is whether it was such a case where the unconditional order was inevitable. Now the point we have to decide here, was it such a case where the conditional or unconditional order is inevitable?
Yes.
We have to go into that.
Yes.
One was the issue, I think, leave it to the commercial side.
That part, I know, that is a fait accompli. Even if it goes before the 150, I mean the commercial court to decide 151, we all know what would be ordinarily the fate of it. Yes. But so far as there are two aspects of the order is concerned. Number one, whether if the assumption of jurisdiction is not permitted by law, assumption of jurisdiction by a writ court, in the circumstances are not permitted by law, then the entire order should go. Whatever is the direction.
Whatever. Yes.
The best direction would also.
Yes.
So I'll come back to my first point.
Yes.
That whether a judicial order is capable of a judicial review under Article 226.
That's the only point.
That is the only point.
Second ancillary point is that suppose it is maintainable otherwise, then in the facts of the case, as you said, whether it comes within that particular purview of clause B of section 36(3),
Yes.
that's the ancillary question.
Absolutely.
Yes.
Absolutely.
You address me on those points.
Yes. Now, so far as the first point is concerned, well, I'll not take your lordships to Mirajkar, but I think Mirajkar in mind, that was possibly the parent judgment subject to again correction by the court, where the Honorable Supreme Court, I think it's a 7 judges bench, held that no certiorari is available against a judicial order. Please just have a look to one paragraph of Mirajkar. Your lordships are considered on this. This is the general one. But this is, we have forgotten those AIR citations. We have all become used to SCC online citations. They have in fact renewed.
But in those days, the IR was the only one was very good.
And for us in High Court, of course, I'm not that primitive. It was only
True, that was the only authentic journal in Calcutta.
Yes. Now, look at this mirror. No, I'm sorry, it's a 9 judges bench.
Naresh Sridhar Miraj Kumar.
Yes.
Mirajkar.
1966 SC online SC 10. Which is equivalent to
1961 Supreme Court page 1.
Yes, 67.
67 Supreme Court page 1.
Now, only one paragraph 61. It will be mirrored at printed page 24. But apart from this aspect of the matter, we think it would be inappropriate to allow the petitioners to raise a question about the jurisdiction of the High Court to pass the interim order in proceedings under Article 32, which seeks for the issue of a writ of certiorari to correct the said order. If questions about the jurisdiction of superior courts or plenary jurisdiction to pass orders like the interim order are allowed to be canvassed in writ proceedings under Article 32, logically, it would be difficult to make a valid distinction between orders passed by the High Court's inter-parties and those which are not inter-parties in the sense that they bind strangers to the proceeding. Therefore, in our opinion, having regard to the fact that the interim order that has been passed by a superior court of record is exercise of inherent power, the question of existence of the same jurisdiction, as well as the validity and propriety of the order, cannot be raised in its proceedings taken up by the petitioners for the issuance of a writ of certiorari under 32. In our case, where it is 226. But this is the crux. This is the clinching paragraph.
I think subsequently there has been a judgments where the distinction between 226, 226, 227
Is
sought to be made. I think Suradev Rai's judgment is
here.
Yeah, commercial, my lord. It's a really-
Radhesham has diluted it, I know.
Suradev Rai had said that against a civil court's order, A 226 and 227 is maintainable.
Radhesham has said it has to be a demarcation. I think there was some kind of a discussions which were made in Radhesham.
Suradev
But he
absolutely
also considered this judgment, both these.
Radhesham versus Sabina.
My lord has laid out East India Commercial Constitutional Bench has laid out the principle. Every High Court has
NKC projects are- But the NKC projects judgment, Lakshya considered both Suryadev Rai as well as Radhesham
Because-
versus Sabina. Please have a look.
We are just
the opportunity.
taxing our memories, nothing more than that.
So it's a big learning. So be part of this proceedings.
Yes.
Well, apropos that what has fallen just from your lordships, please take me to paragraph 7 of NKC. Just Miller on the issue, my lord said. Please take para 6. Miller, your lordships have framed the question over there. The above quoted order is essayed in the initial opinion, and the plea is taken when the repetition under Article 226 is maintainable against judicial orders passed by commercial court. There has been divergence of views with regard to the exercise of jurisdiction by the High Court under Article 227. Both the provisions are integral part of the basic structure which can neither be whittled down nor be taken away to a legislative field. Power is immune from being curtailed and or abridged even by promulgating legislation. Yet there has been a constant debate on the scope and jurisdiction upon the High Court to be exercised in a specific field. Without adverting to go to the earlier judgments touching upon the said issue and keeping in mind that both provisions confer power on the High Court to do a thing, reference can be made to a two-judge bench decision of the Apex Court in the case of Suryadev Rai. The identical issue was raised with the interlocutory order passed by a civil court was essayed under section 115 of the CPC, and thereafter the order disposing of the revisional application was challenged under 226 before the High Court. After the matter travelled before from the High Court to the Apex Court, the solitary point which was urged before the Supreme Court was as to whether Article 226 of the Constitution can be exercised by the High Court against an order passed in a civil proceeding by a civil court. Although the Apex Court held that in upholding the powers to be exercised by the High Court under the jurisdiction, such powers should be exercised only in the event of failure of justice or existence of patent error manifest from the record, and above all to keep the courts within the precincts of law. So far as the supervisory jurisdiction exercised by the High Court Article 27 is concerned, the Apex Court in unequivocal terms held that such power is exercised to keep the tribunal and the court subordinate to it within the peril of law, and any transgression therefore would entail such orders susceptible to be interfered with. Ultimately, it was held that there is no absolute embargo created under Article 26, more particularly statutory jurisdiction of the judicial orders, and in a given situation, the court may interfere with the judicial orders provided the case comes with the ambit of situations under Suryadev. The relevant portion of the judgment reads thus: such like matters frequently arise before the High Courts. We sum up our conclusions in a nutshell, even at the risk of repetition, and state the same as hereunder. Amendment by Act 46 of 1999 with effect from 1st July 2002 in section 115 of the Code cannot and does not affect in any manner the jurisdiction of the High Court under 226 and 227. Interlocutory orders passed by the courts subordinate to the High Court against which remedy of revision has been excluded by CPC amendment are nevertheless open to challenge in and to be subject to statutory and supervisory jurisdiction. Statutory under Article 226 for directing Gross errors of jurisdiction, that is when a subordinate court is found to have acted without jurisdiction by assuming jurisdiction where there exists none, or in excess of its jurisdiction by overstepping or crossing the limits of jurisdiction or acting in flagrant disregard of law or the rules of procedure or acting in violation of the principles of natural justice where there is no and thereby occasioning failure of justice. Supervisory jurisdiction under Article 27 of the Constitution is exercised for keeping the subordinate courts within the bounds of their jurisdiction. Where the subordinate court has assumed a jurisdiction which it does not have, or has failed to exercise a jurisdiction which it does have, or the jurisdiction, though available, is being exercised by a court in a manner not permitted by law and failure of justice or grave injustice as occasioned thereby, the High Court may step in to exercise its supervisory jurisdiction. Be it a writ of jurisdiction or exercise of supervisory jurisdiction, none is available to correct mere error of fact or of law unless the following requirements are satisfied. The error is manifest at the phase of the proceedings, such as when it is based on clear ignorance or utter disregard of the provisions of law and a grave injustice or gross failure of justice as occasioned thereby. A patent error is an error which is self-evident, that is, which can be perceived or demonstrated without involving in a lengthy or complicated argument or a long-drawn process of reasoning. Where two inferences are reasonably possible and the subordinate court has chosen to take one view, the error can be called gross or patent. The power to issue writ of certiorari and supervisory jurisdiction are to be exercised sparingly and only in appropriate cases where the judicial conscience of the High Court dictates it to act lest a gross failure of justice or grave injustice should occur. Care, caution, and circumspection need to be exercised when any of the aforesaid two jurisdictions is sought to be invoked during the pendency of any suit or proceedings in a subordinate court, and the error, though calling for correction, is yet capable of being corrected at the conclusion of the proceedings in an appeal or revision preferred thereagainst, and entertaining a petition invoking certiorari or supervisory jurisdiction of the High Court could obstruct the smooth flow and or early disposal of the suit or proceeding. The High Court may feel inclined to intervene where the error is such as, if not corrected at that very moment, may become incapable of correction at a later stage, and refusal to intervene would result in travesty of justice, and where such refusal itself would result in prolonging the writs. The High Court, in exercise of certiorari or supervisory jurisdiction, will not convert itself into a court of appeal and indulge in appreciation or evaluation of evidence or correct errors in drawing inferences or correct errors of mere formal or technical character.
This is very important.
Yes. In practice, the parameters for exercising the jurisdiction to issue a writ of certiorari and those calling for exercise of supervisory jurisdiction are almost similar. And the width of the jurisdiction exercised by the High Court, unlike the English courts, has almost obliterated the distinction between the two jurisdictions.
226, 227.
Yes, the width matters. It is not the extent, it is the width. While exercising jurisdiction to issue a writ of certiorari, the High Court may annul or set aside the act, order or proceedings of the subordinate courts, but cannot substitute its own decision in place thereof. In exercise of supervisory jurisdiction, the High Court may not only give suitable directions so as to guide the subordinate court as to the manner in which it could act or proceed thereafter or first. The High Court may, in appropriate case itself, make an order in supersession or substitution of the order of the subordinate court, as the court should have made in the facts of the case. Now, this is how Surya Dev Rai was elaborately what should I say, itemized as to how the jurisdictions should be exercised. But Radhesham says something different. That is the next paragraph that your Lordship had considered. Subsequently, another two judgment of the apex court in Radhesham versus Chobinath and others doubted the correctness of Surya Dev Rai, and being equal strength bench, refer the matter to the Honorable Chief Justice of India to constitute a larger bench. The three-judge bench of the Apex Court in Russia answered the reference and held in unequivocal term that the writ petition under Article 226 of the Constitution is not applicable against a judicial order. I think that's the end of the matter. It may be a good order, it may be a bad order, whatever it is, not applicable.
To be more precise.
Yes, then, to be more precise, it is held that judicial orders are not susceptible to be challenged for a writ of certiorari provided under 226 and thereby overrule the observations of Surya Devrai, where it is held that the writ of certiorari is maintainable against a judicial order. The observations in paragraphs 23, 4 and 5 of Radhesham is quoted. Thus, we are of the view that judicial orders of civil courts are not amenable to a writ of certiorari under Article 226. We are also in agreement with the view of the referring bench that a writ of mandamus does not lie against a private person not discharging any public duty. Scope of 227 is different from 226. We may also deal with the submissions made on behalf of the respondent that the view in Surya Dev Rai stands approved by a larger bench of Sahil versus Manoj Kumar in so-and-so, then Mohari Emporium versus GB such and such, then Salim Advocates Bar Association, and on that ground, the of the views cannot be gone into by this bench. In Sahil versus Manoj Kumar, no reference has been made to Surya Dev Rai. The same is only for the purpose of the scope of power under 227, as is clear from paragraph 3 of the judgment. There is no discussion on the issue of the maintainability of a petition under Article 226. In Mahendra Sari, reference to Surya Dev Rai is made in paragraph 9 of the judgment only for the proposition that no subordinate legislation can whittle down the jurisdiction conferred by the Constitution. Similarly, in Salem Bar, reference was made to Surya Dev Rai for the same purpose. We are unable to accept the submission of the learned person. Accordingly, we answer the question referred as follows. 1. Judicial orders of civil court are not available to writ jurisdiction under Article 226. Jurisdiction under 227 is distinct from jurisdiction under Article 226. Contrary view in Surya Dev Rai is unable. Therefore, I come under the first clause. Exercise under 36 is a judicial function. Therefore, writ was not maintainable under 226. Then I come to the 9th paragraph. Even a division bench of this court is in HARISH versus so-and-so decided on so-and-so after taking note of the full bench decision of this court in Muhammad Saud, which was affirmed by the Apex Court in so-and-so, held that the writ appeal against the judicial order is also. Though the case referred by the counsel for the appellant, we do not find any substance. Now, please take paragraph number 11. Be that as it may, the judgment entered in Radhesham has created an embargo in entertaining an application under Article 226, more particularly certiorari against a judicial order passed by a court in a civil proceeding. The writ is in the nature of certiorari, not an appropriate remedy for an aggrieved person. But the best part of this judgment in 3 paragraphs, your lordships have considered extent of 226, extent of 227, and extent of petitions nomenclated as 226 and 227. First is para 11. Be that as it may, the judgment rendered in Radhesham has created an embargo in entertaining an application under Article 226, more particularly the writ of certiorari against the judicial orders passed by the court in the civil proceeding. Therefore, the writ in the nature of certiorari is not an appropriate remedy for an aggrieved person. This is 226. Next paragraph is on 227. It leads to another aspect as to whether power of superintendence has also been taken away in relation to judicial orders passed in a civil proceeding. The answer is negative. The power of superintendence encapsulated within its fold to keep the courts and the tribunals subordinate to it within its territory, to travel within the circumference of law, and in the event it is found that the court has transgressed the boundary, the High Court may pass appropriate order which is just in tune with the settled legal proposition. There is no fetter either in Surya Dev Rai or Radhesham created in entertaining an application under Article 227 against a judicial order passed in a civil procedure. Therefore, we have no hesitation to hold that the application under 227 is maintainable in such situation. The situation is what? Whether the court has transgressed the limits of law. Not whether the order is good or bad.
Direction of a fact or a law
Yes.
is not
Yes.
coming.
Yes.
Is only to keep them within the precincts of the law. You should not travel beyond it.
Yes. Then kindly take para 13. This is where petitions nomenclated as both 226 and 227, how are they to be dealt with? A piquant situation has arisen when the application is captioned as an application under Articles 226 and 227 of the Constitution.
This is a very common phenomenon here.
But in many courts,
Common phenomenon for one reason, because both the applications are captioned as a writ applications. Unlike the Calcutta, where the 227 is coming under the revisional jurisdiction. So it is still captioned, or a nomenclature is given as a civil order. CO is not given as WP. So that is what I found. That's why this observation came.
Can we consider, your lordships have taught us what is the difference between a petition, plaint, and application. Petitions and plaints institutes a proceeding. Those are instituting a proceeding. Whereas applications are in the proceedings.
In the proceeding, in aid of.
Yes, therefore, when we describe a 227 as an application, we do not describe 226 as an application.
But what you said, I correct myself, because that was a wrong teaching that was done.
To me.
You said that your lordship stopped.
Yes.
So that's why I say it's a wrong teaching. For one reason. Section 8 of the West Bengal Land Reforms Act talks about the preemption proceedings.
Yes.
It never talks about the petition. It talks about an application under Section 8 of the West Bengal Land.
Right.
The question arose that if it is an application, whether there is any applicability of Section 5 of the Limitation Act. Because the Section 5 applies only to an appeal, revision, review, and applications.
Not against plaint.
No, not against plaint. It does not lie.
Yes.
So the question arose, it is an application. Then in that event, whether Section 5 will apply.
Yeah.
Because the limitation is given in Section 8 itself.
Right.
Calcutta High Court, one view was, why not? But later on, it was not accepted. It says, no, it is not. Ultimately, the Supreme Court in Gautam Roy, I believe, the Gautam Roy's case, the Supreme Court then held that the difference between applications, petitions, and the plaintiffs, that if the proceeding originates either on the basis of a petition or the application, then that is an original proceedings, and the application would be treated akin to a plaint. Akin to a plaint. And once it is treated akin to a plaint, then Section 5 has no manner of applications.
Yes.
So application is also inbuilt.
Yes.
Applications under Articles 226 and 227. That is the
rule talks about the application.
Yes, in
Not
fact,
petition.
my lord, in our rules also, in Calcutta rules also, initially provided as application. Then this
Now it is a petition.
Now this petition. So your lordship will kindly, yes.
You are absolutely, there is no difficulty. What I say that sometimes the application is also treated as a plaint, akin to a plaint. Akin to a plaint.
My lord is referred to
11, I think this one.
right hand side.
No, left hand side.
No, right.
right. In an application for direction of writ of mandamus, prohibition, warrantor, or any other direction, or ordered under Article 226 of the Constitution or an application under 227 of the Constitution
Application.
will be addressed to the Court of Chief Justice.
That is why in all the petitions here, we write an application under articles.
We are trying to take bill 2. Unless directions directed otherwise, the only category of cases will be placed under petition big. What will be placed? Writ petitions relating to PRA. Writ petitions challenging violations of Act. Writ petitions against orders of SAT, CAT, whatever. Writ petitions relating to admission and recognition of so and so.
So in that sense, we understood
Yes.
applications and petitions,
Yes.
there is no distinction as such.
Yes.
In view
You are correct. That was the view. Then now sometimes the latter on these views are also, it depends
Yes.
that how the proceeding originates. It's not a supplemental proceeding or an incidental proceedings where I can think about the application to have been made.
Right.
If it is an independent proceedings, then in that event, I think application sometimes is treated as the petition or a plaint as well. It's interchangeable,
Yes.
depending upon the nature of
The proceedings.
this.
So,
So I correct myself.
So the correction is applications instituting the proceedings are to be treated as claims.
Sometimes
Yes.
it depends upon the nature.
Yes. Otherwise, when application
Otherwise, it is
Yes.
within the proceedings. It has to be
right. Now, kindly take me paragraph 13 minute where your lordships were considering the applications which are branded as 226 and 227. A piquant situation has arisen when the application is captioned as an application under Article 226 and 227. Both the provisions have been resorted to, but the categorization of the case appears to have been done treating such application to have been filed under Article 226 of the Constitution, and the learned single judge who passed the impugned order was conferred with the jurisdiction determination to deal with such application. There is no incongruity on our part in proceedings on such basis that an application under Article 226 of the Constitution is entertained by the single bench against an order passed in execution of decree by the commercial court and being judicial order, writ of certiorari is not an appropriate remedy, as the same is not maintainable in view of law. Similarly, your lordships have considered three situations or three sort of proceedings.
Yes.
Now, this is to answer your lordship's query. Now, so far as the Arbitration Act is concerned, where the Supreme Court again has carved out two situations, again, which your lordships have considered, which is the deep industries matter. Please have a look to this. proceed on the basis that the learned single judge had exercised 227 jurisdiction. Let us, for the time being, proceed on that basis. Please look into this judgment where the Supreme Court had carved out the exception. What is the exception? Patently lacking or in inherent jurisdiction. Kindly look into this judgment. This again, where the lordship have considered in Sunflag iron and steel. I'll place that judgment also. But this is 2020, volume 15, Supreme Court cases 706. Please have a look to it. Only one paragraph, paragraph number 17, 17. Which my lord will find that page.
No, I got it. At page 714.
714. This being the case, there is no doubt whatsoever that if petitions were to be filed under 226, 227 against orders passed in appeal under 37, the entire arbitral process would be derailed and would not come to a fruition for many years. At the same time, we cannot forget that Article 227 is a constitutional provision which remains untouched by non-obstante clause of Section 5 of the Act. In these circumstances, what is important to note is that though petitions can be filed under Article 227 against the judgments allowing or dismissing first appeals under Section 37, yet the High Court would be extremely circumspect in interfering with the same, taking into account the statutory policy as adumbrated by us herein before, so that interference is restricted to orders that are passed which are patently lacking in inherent jurisdiction. But the commercial court did not mirror the
inherent lack of jurisdiction.
There is no inherent lack of jurisdiction. That is the only jurisdiction available to my learned friend's client. They have invoked the jurisdiction. Quite rightly. I don't say that they have wrongly invoked the jurisdiction under Section 36 before the commercial. I can understand a matrimonial court will not entertaining an application under 36. Then will not para 17 of Deep Industries could have had an application. Then with another judgment, I think this also your lordships have considered Nava Yuga. No, I think your lordships have considered Bhaven construction. Please have a look to Bhaven construction. Here where the Supreme Court says exceptional rarity and when the power is exercised in bad faith.
Is the then Chief Justice of India, Justice Khanna's judgment.
This is where Justice RAMAN. He was not the Chief Justice then. This is 2022, volume 1 SCC, page 75.
Which paragraph?
Kindly first take a few paragraphs of this judgment. Paragraph 5 first. In any case, the appellants appointed so-and-so to act as arbitrator. Respondent number 1 preferred an application under Section 16, disputing the jurisdiction of the arbitrator. On so-and-so, the arbitrator rejected the application and held that the sole arbitrator had jurisdiction to adjudicate the dispute. Then please take paragraph number 17.
SBP has also restricted the applicability of 226 and 227. I think SBP and Patel Engineering.
Yes. That way I don't have
2005 Supreme Court, I believe.
That is
volume 6 or 8 of 6 or 8 SCC.
But I'll trace it out. But I don't
SBP Limited versus Patel Engineering.
Now please consider my learned junior is Now please take note paragraph number 80.
SBP is there. SBP. What is the citation?
2005 8 SCC.
So I was not wrong. 2005 volume 8 SCC page 615.
618.
618. My brother.
Here, here, page 80.
Yes.
Bhavan construction, page 80 is referred.
Oh, yes, it is referred. In the quotation, last paragraph 6.
Sardar Sarovar.
Right.
Paragraph 6. I think in the right-hand side page, the first paragraph of SCC.
Reminds me of Mr. Shoktina Progress.
Not even nearer to him. Definitely not. Yes, which paragraph?
I was at paragraph.
No, you have referred paragraph 5, then.
Please come to paragraph 18 then. Next. In any case, the hierarchy in our legal framework mandates that a legislative enactment cannot curtail constitutional right. In Nivedita Sharma, the court referred to several judgments and held, we have considered the respective argument submissions. There cannot be any dispute that the power of the High Courts to issue directions, orders, or writs, including writs in the nature of habeas corpus, certiorari, mandamus, quo warranto, and prohibition under Article 226 of the Constitution is the basic feature of the Constitution and cannot be curtailed by parliamentary legislation. L. Chandra Kumar. However, it is one thing to say that in exercise of power vested in it under Article 226 of the Constitution, the High Court can entertain a writ petition against any order passed by or action taken by the state and or its agency, instrumentality, or any public authority or order passed by a quasi-judicial body authority. And it is an altogether different thing to say that each and every petition filed under Article 226 of the Constitution.
That's a discretionary jurisdiction. It is not a.
Yes. Then after the quotation, please take the 5 lines. It is therefore prudent for a judge to not exercise discretion to allow judicial interference beyond the procedure established under the enactment. This power needs to be exercised in exceptional rarity, wherein one party is left remediless under the statute or a clear bad faith shown by one of the parties. This high standard set by this court is in terms of the legislative intention to make the arbitration fair and efficient. Then the deep industries is again considered. Then it must be a case of exceptional rarity or bad faith on the part of one of the parties. These are very, very, very exceptional situations which your lordships have carved out where there is a limited applicability of Article 226 of the TANDON. But a long judgment.
2005 8 SSCs.
Then the Supreme Court applies the principle at paragraph 20. 20. In the instant case, the respondent number 1 has not been able to show any exceptional circumstances of bad faith on the part of the appellant to invoke the remedy under 227. No doubt the ambit of 227 is broad and pervasive. However, the High Court should not have used its inherent power to interject the arbitral procedure. Interject because it was a Section 16 application. Therefore, these are the exceptions that has been carved out. Now, please take note one more judgment, and then I place my lord's judgment in some light. Please take note this Nava Yuga. This is 2021. SCC Online SC 6469. So this is against an order under 36. Deep Industries was against an order under 37. Bhavan Construction against an order under Section 16. And this one against an order under Section 36. So this is reported by the This is a very, very short judgment. Please take with the third paragraph. And arbitral
Paragraph.
with the third paragraph and arbitral award.
Oh, that's true. 4th paragraph is the report. I think they have reiterated the law.
In paragraph 3.
They have simply quoted that what it has.
Yes.
Section 34, then Section 36 application, Interim order 4 is the deep industries have been quoted and applied and
Nothing new.
accepted.
But why I am showing this, because this emanates from
From section 36. I
Okay,
understood.
principles
I understood.
are-
Understood.
same principles again. Now please have a look to your Lordship's judgment
Huh.
in Sunflight. This is
Case of Hara.
2025.
No, 618.
Yes. This is.
Yeah.
No, we don't.
Good. I was right. Right inside top paragraph. Paragraph 45.
But your Lordship did not want me to compare with some of them. Yes, we disapprove the procedure adopted
This
by.
says that every order passed by the arbitral tribunal is not susceptible to be challenged under 226 or 227. You have to wait, make a ground at the time of section 34.
Just like commercial
I
courts.
think it is a 5-judge bench decision, I believe. 618, if you can.
Seven.
7.
Neither this nor neither this nor that. Because it is time bound.
But I tell you, this has been explained, interpreted in a different judgments. That's why I'm saying upholding the maintainability of 226.
Yes. Yes. That's why Deep is there. Deep has considered.
No, it's a 7-judge bench.
Yes, so Deep has considered by SBP.
But in this, there is a complete embargo.
Complete impact. Complete impact.
It is.
Same report is
Now the lordship, thank you.
Now, what is the next judgment? Which you-
Next one is that of this honorable bench, 2025 A6 Online Orissa, 3025. Okay. Oh. But I'm so sorry, we don't have, the hard copies of that. It's my mistake. I forgot to tell you.
No, just give me, they can print out.
2025 is, for a moment, can you have a look?
I don't want to raise an objection. My friend could have shared all, knowing fully well that I'm appearing online, could have shared all this earlier. I don't want to raise an objection. I'll meet it. No problem. I'm really handicapped. I thought he'll cite one or two. He's citing a dozen judgments.
No, citation is
Citation
given.
is 2025 SCC Online, Orissa 3025.
Can any one of your junior WhatsApp to me all the citations, please, so that I'll deal with them in one go. Nobody.
So we have handed over hard copies to your junior over here.
I understand, sir. But you must know that I'm in virtual, and you know that I'm going to be in virtual.
Mr. Pari is here. I've handed over copies to him.
Let him argue then. If you want him to argue and not me to argue, then that's right.
Mr. Pari, you can give a citation. You can give a citation because he is there in the chamber.
Receive after they were scanning.
No, please, not scanning. You can give a citation so that he has the book with him or he has everything. He can go through it.
It's my system.
You just give him the citation.
just make a WhatsApp there.
Make a WhatsApp and do it.
That's all. But I'll still meet him now because the fundamental answer is going to be 3 sentences for me for any number of things.
Yes.
Right. The answer is going to be threefold, which I'll address it whenever my turn comes.
What is the
Now, your lordships may kindly take note. This arises out of an order under section 60. And naturally, your lordships have held that why do you come in the interregnum, wait for the award to be delivered. If it goes against you, you can take this also as a point. But here, Bhavan and Deep were considered by your lordships. And now please take the paragraphs 18 to 24.
That's why I remember, because I have taken this constitution bench decision of SBP.
Yes.
And then I said that majority view is in favor of not entertaining 226 and 227.
Please take note paragraphs 18 onwards. 18, 1 8. What can reasonably be deciphered from the judgments, as mentioned herein before, that the power of judicial review under Article 226 or the power of superintendence of courts or tribunals under Article 227 are integral part of the basic structure which cannot be curtailed and/or abridged, even under the legislative fiat. There is no absolute fetter put in the Constitution bench decision rendered in SBP on exercise of power under Article 226 to 227. But such powers should be exercised with great caution and circumspection when the arbitral tribunal has acted in bad faith. The writ court can also interfere if the order passed by the tribunal which lacks inherent jurisdiction or a perversity can be attached to an exercise of power while passing an order. Normally, the writ court should refrain from encouraging the litigants to invoke the extraordinary jurisdiction conferred under Article 226 to 27 of the Constitution against each and every order of the arbitral tribunal unless the order meets the test of perversity or lack of inherent jurisdiction or bad faith. The litigant is not remediless as the order upholding the jurisdiction, but this may not apply in the facts of my case. In para 20, the exposition of law as above leads to another 4th point as to whether the writ court taking shelter under the same may interfere with orders of the tribunal where the plea of insufficiency of stamp was rejected. the record would reveal that the plea of insufficiency of stamp applicable, but this was a case of, your lordship would recollect whether it is an agreement.
NM Glover.
Yes, yes.
NM Global.
But finally, please take paragraph 20.
7 judges.
The single bench has in fact entered into the domain of an arbitral tribunal in ascertaining the nature of the contract and held that the decision of the tribunal in arriving at a decision that it is an agreement for sale and not a sale agreement is erroneous. It admits no ambiguity that the arbitral tribunal is conferred with the jurisdiction to interpret the contract, including the nature of the agreement for the purpose of ascertaining the requisite stamp duty leviable thereupon, and if a decision is arrived at, it cannot be said to be perverse of the arbitral tribunal in the act's jurisdiction to decide. It is a wrong decision. But that does not rob the tribunal of its power to exercise jurisdiction.
What has happened against this judge?
Yes. Now, Miller, against my lord's judge, well, I am not aware.
Your juniors must be more.
I'll be very candid, but I didn't try to find out what is different to it. It is that way. If you always say, you just search it. Your lordship have also referred to Punjab State Electricity Board versus MTA, their MD creations. For the time being, I don't trouble your lordship with those. Now, coming back to the case, the submission was before the commercial court at the first instance is there is a fraud. Why fraud? There is no pleading of fraud. Be that as it may. Why fraud? Because in another arbitration proceeding stemming from the original agreement, now the agreements are different. I'll give you a lot of the facts later on. A tribunal had passed an award which was found fault by a single judge of the Calcutta High Court, and thereafter went up before the division bench under 37. And when it went to Supreme Court at the interlocutory stage, the parties agreed that no, the award should be set aside. The Honorable Supreme Court appointed an arbitrator by setting aside the award, the learned single judge's judgment, the learned division bench's judgment. Therefore, there is an inference of fraud in this arbitration proceeding as well, which is comprised of 3 honorable retired judges, one of whom is a retired Supreme Court judge. So this is the analogy, the only submission, the entire submission direct of any pleading. I'll not take that as a very big point. If it is a fraud, it is a fraud. Though your lordship has said that I have held that fraud needs to be pleaded and proved, but for the timing, I keep aside all those high technical issues. The point is, because X is bad, therefore declare Y also bad. 2 independent tribunals applying their mind, passing orders, not set aside on merits, set aside on by consent of parties. As your lordships know, that again, compromise, consent decrees are known to be agreements with an approval of the court or a stamp of the court. Here I have not agreed. First, the parties have to agree to substitute an arbitrator, and whether that can be done under 36 or not is a different question altogether. Now, please have a look to the commercial court's order. But I'm told, Milord, Sunflag's order has gone to Supreme Court. Notice has been issued. No stay. Even stay doesn't matter. The point of law decided remains. So long it is not satisfying. Oh, well, the court had directed the arbitration procedure to go notice issued, arbitration procedure to go. Now, your Lordships may kindly take below the commercial court's order at page 142. So please take the first paragraph. I'll only read one paragraph on fact as to what was the submission. We're at page 400 and, 142. Please take the second paragraph. The petitioner has filed the present petition with a prayer to stay the operation of the arbitral award relating to the dispute relating to the agreement of the wagon investment scheme. The petitioner has already filed a petition under section 34. For setting aside the arbitral award, and it is patently illegal, perverse, as well as bad in law. It is contended by the petitioner that the learned tribunal directed the petitioner to pay a sum of ₹1707 crores is based on no evidence, as the opposite party was unable to construct a private siding at Niagara for which they cannot receive benefits of freight rebate and guaranteed rates under the agreement, and awarding claim 3 relating to loss of profit due to non-supply of 1,860 rates is contrary to the terms of the agreement. Further, under the separate arbitration proceeding, well, this is the main thrust. Further, under the separate arbitration proceeding between the present opposite party and the Southeastern Railway arising out of dispute relating to the same wagon investment scheme, the arbitral tribunal awarded a sum of ₹1301 crore. The High Court, video order dated 8/8/2023, has observed that the award has been obtained by act of fraudulence and granted unconditional stay of operation of the award. Well, this is by Justice Saraf's order. Subsequently, the Honorable Apex Court, video order dated 25/1/2024 in SLP, has been pleased to set aside the award and appointed Honorable Justice V. Subramaniam, former judge of the Supreme Court, to adjudicate the dispute between the parties. Hence, unless the enforcement of the aforesaid arbitral award is stayed during the pendency of the arbitration proceeding, the petitioner, who is an organization of the government of India, will be highly prejudiced and suffer from irreparable loss. Hence, for ends of justice, the petition may be allowed. Now, we are pausing here for a moment. There are two aspects. One is the monstrosity of the figure. 1,707 crores has been told 200 times. Therefore, it should be stayed. And the second aspect is Supreme Court has appointed. So kindly have a look to the Supreme Court's order. I'll come back to the commercial court's order on what parameters will the Honorable the judge had proceeded to Supreme Court order.
Come after 2 minutes.
Please take note, page 472. Well, I'll come back to the order of the commercial court. Now, this is the order of at page 472. This is the order of
Order of what?
of the Supreme Order of the Honorable Supreme Court, which is being referred
400?
470. This is 25th of January 2024. Kindly take the next page, para 2. The following order ensues with the consent of the Union of India, which is represented in these proceedings by so and so appearing for the respondent. 1. By consent of parties, the arbitral award order dated so by passed by the learned single judge and the improved order passed by the division bench of the Calcutta High Court are set aside. Honorable Justice B. Ramasubramaniam, former judge of the Supreme Court, is appointed as the sole arbitrator to adjudicate on the disputes arising out of the wagon investment scheme agreements dated so. The sole arbitrator shall conduct the arbitral proceeding afresh, bearing in mind the stage which was reached before the earlier arbitration. The parties would be at liberty to supplement their pleadings with such additional pleadings as they would seek to file within the timeline set by the arbitrator. The parties will keep where the rest of the procedural directions. Now, this is being cited as a precedent for an order to replace or to set aside the arbitral award and Millard to refer the matter to an honorable judge.
Yes.
Now, please come back with it to the commercial court's order, which was at page 142.
Yes, I have read it.
Yes,
I've read the whole of the order.
yes. Now, please take note of a few lines of this order as to how. Assuming that this can be looked into by the High Court, kindly take note page 151, the last 3 lines. For contra,
Huh?
151, last 3 lines.
Yes.
Per contra, the learned counsel for the opposite party, that is my client, submitted that no case has been made out by the petitioner to obtain unconditional stay of the award. Further, in the present case, petitioner has failed to plead and prove alleged fraud which cannot be sustained. There is a specific point taken. Then please take Millard, page 153, the last 5 lines. 153. Hence, on going through the materials available on record, and this is very important, this is the Honorable Judge's finding, and in absence of pleading by the petitioner regarding the fact that the arbitration agreement or the contract which is the basis of the award or making of the award was induced or affected by fraud or corruption, I am of the opinion that the petitioner is not entitled to an unconditional stay of the arbitral award. Then please take Millard. Now Millard, the directions are passed at page 154.
Direction upon them to deposit.
Deposit, yes. Deposit and secure. Partly deposit, majority, a minuscule part is directed to be deposited, and the maximum of the damages part, Millard, is directed to be secured.
Yes.
Now, your lordships may kindly take Millard the judgment under appeal. But these are all my submissions in the alternative. Fundamental submission, repetition, not interchangeable. Because it is maintainable on very limited grounds. Petition could not have been entertained because the small or the short Millard exceptions that the Supreme Court has carved out is not applicable over here. Neither have the learned single judge held that to be so. I'll place the judgment of the learned single judge. It's a lengthy judgment. Please take Millard, page number 55. It starts from page 55. Well, I directly take your lordship to the hygiene part. The learned Judge Miller first held the principle that it is the burden on the award debtor to prove. Please take note, paragraph number 29 at page 70. The language employed in the above section, where the workshops are found, with paragraph 29.
Yes, yes.
The language employed in the above section is unequivocal.
Very line. Burden is on the awarded
Right.
officer.
The principle is formulated by the court, rightly so. Now kindly see how this is being dealt with or analyzed by the single judge. Please come to Miller, page number 74. The emphasis therefore is not merely paragraph 37. 74, paragraph 37. The emphasis therefore is not merely on the existence of or concealment or misrepresentation, but on its impact in the arbitral decision. The award must be shown on a prima facie basis to be consequence of such concealment or misrepresentation. The expression making of the award occurring in the proviso thus takes within its suite not only the final determination but the entire decision-making process, including in particular the conduct of the parties during the arbitral proceedings and the evidentiary foundation placed before the arbitral tribunal. Then kindly takes Miller, paragraph number 41. Or paragraph 40, the last sentence, the last 4 lines. Where such infirmities, Mallets are found that infirmities means not 36(3) second proviso. Where such infirmities are shown to have materially influenced the arbitral outcome, the proviso mandates an unconditional stay of enforcement, excluding the exercise of discretion as to conditions. Then we'll at 41, I would like to skip over, but my learned friend may like me to read it, but therefore I would read it. Otherwise, there may be some allegations of suppression. May read paragraph.
Give me the privilege to read it.
Applying the aforesaid heightened threshold to the facts of the present case, this court is of the considered view that the material placed on record does disclose at least prima facie circumstances which go beyond the procedural infirmities or errors of appreciation. The allegations pertain to advancement and adjudication of claims on the footing that the foundational contractual preconditions stood fulfilled, notwithstanding pleadings and materials suggesting non-construction of Niagara private siding, non-placement of indents, and absence of compliance of essential prerequisites under the governing agreements. These aspects are not collateral or peripheral, but strikes at the very core of the entitlement itself and consequently at the evidentiary basis on which the tribunal proceeded. We are pausing here for a moment, assuming everything to be correct in favor of my learned friend's client. This is not a ground to interfere. That one party is alleging that I have complied with all my contractual obligation, the other party is alleging that no, you have not complied with your contractual obligations, or there is a breach of contractual obligation. This is not a ground at the 36, assuming everything to be correct for the time being. Well, I skip over the next part. I read this because I felt that my learned friend may take umbrage why I have not read that paragraph. Now please take me paragraph 44. It is also pertinent to mention here that section 34 of the Act expressly recognizes fraud as distinct and a grave ground for setting aside an arbitral award by statutorily incorporating it in the rubric of the public policy of India. Explanation 1 to section 34 2BII clarifies, beyond any scope of ambiguity, that an award is in conflict with the public interest of India if the making of the award was induced or affected by fraud or corruption. The legislative formulation elevates fraud from a mere factual allegation to a jurisdictional infirmity going to the root of the arbitral process and the legitimacy of the award itself. Consequently, where credible and prima facie materials of fraud is pleaded and supported by arbitral record, the court is not dealing with a routine challenge to appreciation of evidence, but with an allegation that the very foundation of the award is tainted, rendering it vulnerable to annulment of Section 34. But the specific finding of the learned commercial court is that there is no pleading of fraud. Well, I'll take their petition also. I'll place before your lordships. Then please take me, Lord, paragraph 45, the last 5 lines. The discretion under section 36(3) is not mechanical and automatic, but is structured by statutory threshold, judicial principles, nature of infirmities alleged against the award, thereby requiring a calibrated and reasoned exercise of jurisdiction. Absolutely right. But where is the applicability? Principles where has been correctly in my respective submission formulated. Then please take note paragraph 46 at page 80. We are at page 8. The sixth line. The use of the word shall denotes absence of discretion once the court is satisfied about the existence of prima facie case of fraud. Therefore, when allegations of fraud are not speculative but arise from admitted contractual non-fulfillment or suppression of material facts, the court is statutorily bound to consider unconditional stay by imposition of onerous financial conditions without examining this statutory mandate would amount to failure to exercise jurisdiction vested in law. Now, with respect to this is a speculative case of fraud. Because another tribunal's order has been set aside by consent, therefore there is a fraud by this tribunal. This is the sum and substance of the argument. Then I skip over paragraphs 47, 48, 49. Now please take Miller paragraph 50. Why fraud? This court notes that the petitioner specifically pleaded that the arbitral award passed against the Southeastern Railway arising from the wagon investment scheme and involving identical categories of claims has already been set aside by the Supreme Court in its order with a direction for de novo arbitration. This plea was not collateral or incidental. It formed part of the petitioner's core challenge that the claims themselves were structurally tainted and that the continuation of enforcement proceedings on the same contractual foundation without examining the infirmities noted in the parallel arbitration would perpetrate the very illegality and fraud alleged in section 34 proceedings. Then when I skip over the 34 aspects, please take now paragraph 53. Apart from the express use of the term fraudulent, the pleadings disclose detailed factual allegation, where I'll place the pleadings, which in substance constitutes fraud and misrepresentation. The petitioner has consistently pleaded that the claimant never constructed the approved Niagara private siding, never placed contractual evidence, and did not produce wagon registration fee receipts, and yet most audaciously claimed freight rebate, guaranteed rates, and loss of profit as if all contractual preconditions were fulfilled. It is further pleaded that export-related loss was claimed despite the absence of supporting export data and despite material suggesting misdeclaration of cargo. These allegations are not matters of mere contractual breach, but go to the root of the entitlement and suggest deliberate projection of false factual premises to obtain monetary benefit through arbitration. Then I skip over paragraph 54 then. In the present case, the allegation of fraud as borne out from the pleadings and record is twofold. That is, one relating to the claimant's conduct and the other relating to the manner in which the arbitral process was allowed to culminate in award without going into the facts in proper perspective. First, it is alleged that the opposite party advanced claims for freight rebate, guaranteed rates, and loss of profit under the wagon investment scheme despite non-fulfillment of foundational contractual obligation. The approved loading point under the agreement was Noida private siding, which admittedly was never constructed. It is further alleged that no indents were placed in accordance with the railway procedure and no wagon registration fee receipts were produced. Yet the claimant proceeded on the premise that the guaranteed rates were denied despite compliance. On this basis, it is alleged that the material facts relating to contractual entitlement were either misrepresented or suppressed, thereby inducing the arbitral tribunal to proceed on an incorrect factual foundation. Second, it is alleged that making of the award itself was induced by collusive or grossly negligent conduct of railway officials amounting to fraud on arbitration proceedings. The record reflects, it's very unfair for the councils to point fingers at their respective officers. In fact, we're over here. More than 400 questions were put in cross-examination to my client's witness. The learned tribunal allowed the councils to argue for days together. And again, with deepest of respect to my fraternity, the portions which could not be highlighted by the learned councils, the officers were allowed to argue for days in and days out, so that the railways could argue to their heart's content. And with these casual statements with respect by the learned council, almost implicating their officers only for the purpose of making out a case of fraud and corruption. But I would be taking all responsibility to say that this is highly deplorable, because the persons who argued before the court were not present in the arbitration procedure. Yes, Mr. Pavi was there.
Yes.
I can see the people.
Award is 702. This is allotment fraud. That's what I think so.
Very surprising.
Austerity of an amount cannot be fraud. Then small amounts will not be fraud. If this is the analogy, then if it is an award of, say, 5,000 rupees, it can never be obtained by fraud. If this is the analogy, 1,707 crores, so it is a fraud. But I place the pleas. How could this argument be entertained by the learned single judge on this basis? Neither before the High Court nor before the Section 36 application, there were any pleadings of fraud. There is only one word fraudulent somewhere, I'll show. Now kindly take the fourth to the third line in paragraph B. The record reflects that despite claims running into more than 1,700 crore, East Coast Railway did not yield effective evidence. Did not produce documents where the learned tribunal directed them to produce the original records. And it's not that it was not produced despite a direction, produced and looked into within its custody, and did not meaningfully contest critical factual assertions. But I do not know how to make submissions on this. Where an argument by me may be considered to be very, normal argument, and the same argument may to another judge be of some worth. It's a matter of perception. Now, how could Millard in one sentence, without looking into the records, if at all these can be looked into? I assume for argument that at the 36th stage, where Millard this section uses the expression prima facie, whether at all records can be looked into or not, assuming for argument's sake that records can be looked into and these findings can be reached, but there must be some basis, some analysis. What does one mean by contest critical factual assertion? Then Then kindly take me to the next one. C. The aforesaid pattern of non-defense, when read with parallel arbitral history, under the same scheme and the Supreme Court's order dated so and so, setting aside the Southeastern Railway Award, arising from the same contractual framework, is relied upon to allege that the arbitral process did not operate as a genuine adversarial adjudication, but as a Machiavellian handy tool. Now, I'm just pausing here for a moment, but since such serious allegations have been made, kindly take note. Paragraph, page 106. Just will I digress for a moment.
Yes.
With paragraphs 121 to paragraph 132 are the learned arbitral tribunals adjudicate or analysis of the evidence.
Page number, sir?
Page 106, sir. 106. Your Lordship, kindly read it for your Lordship's consideration. 121 to 132.
Sorry for the interference. In my writ appeal compilation, 106 is not the writ.
106.
It's not
106 is the petition. Is a petition.
Read petition.
Oh, I'm so sorry. There is no writ petition. I'm so sorry.
Paragraphs?
The paragraphs 121 to 132.
No, paragraph 121.
It starts from cost type 121.
There is no paragraph 121.
Yes.
I think.
Well, I'm sorry, Lord. Please take 709. Page 70.
70.
09.
709. Oh, yes. Well, I'm so sorry, Lord. It's
Yes.
this is the analysis, Miller. But in different way, that's something which is to be looked into at the 34th stage. Then, Willard, your Lordship may kindly take, Willard, page number 781. Willard, we have collated as to how, Willard, the witness action went.
Exactly, the conclusion. Read petition.
This is a part of my section, reply to section 34.
Yes.
Then please take my paragraph number 8. After completion of trial, the opposite party claimant commenced arguments on 9th January, that is the 45th sitting, and concluded on 19th February, 55th sitting. The petitioner, that is the East Coast Railways, commenced their arguments on 5th of March, 56th sitting, and concluded on 21st May, 70th sitting. Rejoinder submissions were thereafter were made thereafter, and the matter was reserved for so and so. A total number of 78 sittings were held, and the award was pronounced on such and such. And where the largest single judge says that it was not effectively represented, defended. But in fact, at one place where I have also made analysis of the questions that were put to my witness. I'm trying to find out that.
Number of
Questions. Which
no,
sorry. Now we're coming back to the judgment under the appeal before my lords. I was at paragraph 50, 54 बोल दीजिए. Yes, 54. Yes, 54. I was there. Now, coming back to page number 84.
Oh no, you have read all these three graphs.
Yes,
3/4, 2/4.
correct. Then your lordships may kindly take para 57. In any case, the court cannot mechanically proceed to impose monetary condition under sections 36(3) without first undertaking the threshold inquiry mandated by the second proviso, especially when the court itself records that during the course of hearing, the learned counsel for the petitioner submitted that the petitioner is entitled for unconditional stay of the award as prima facie. It has been obtained on the basis of fraud, patently illegal, perverse, and based on no evidence. The discretion to impose condition arises only after the court forms an opinion that the case does not fall within the statutory category warranting unconditional stay. Failure to examine whether the allegations of fraud are required to be addressed at the stay stage results in inversion of statutory sequence, where the exception is ignored and the general rule is applied by default. Such an approach defeats the legislative intent underlying 2021 amendment, which was introduced to prevent the enforcement of awards that are prima facie tainted by fraud, corruption, even at the interim stage of Section 36, pending final adjudication of Section 34. Therefore, the exercise of jurisdiction under Section 36(3) necessarily obliges the court to apply its mind to the pleadings and record to ascertain whether the challenge raises a prima facie case of fraud affecting the arbitration agreement problem. Only upon recording a reasoned finding that no such prima facie case exists, can the court proceed to consider the proportional conditions for stay, including deposit, etc. Then Justice Saraf, paragraph 59. The court also notes that the petitioner has relied upon the order of the Calcutta High Court dated 8/8/23 in proceedings arising from the Southeastern Railway arbitration, wherein serious prima facie observations were recorded regarding the integrity of the claims under the same wagon investment scheme. Well, I would not waste your lordship's time by reading this unless my learned friend wants me to read, because the Supreme Court has set aside this order. So whatever were the prima facie finding, they have gone. But still, if your lordships desire, I can read those.
You please leave something to me, sir. I have to argue.
I read that. I read that.
You're arguing for my officers, you're arguing my case. Give me some.
May I place this part also? The Calcutta High Court observed therein, which are as follows, paragraph 44. In the present case, with respect to the conduct of the parties, this court observes a disconcerting trend where the hallowed principles of honesty, integrity, and probity seem to have gone up in smoke. It shocks the conscience of this court to observe that the railways, in defending a claim valued at rupees 4,000 crores, declined to present any witness. So before Justice Saraf, there the railways did not produce any witness. In my case, they had produced witnesses then. Subsequently, in the arbitral proceeding, the lackadaisical and indifferent attitude of the railways during the cross-examination of the claimant's witness, as also noted in the arbitral award, leaves much to be said about the sordid state of affairs and absolute apathetic approach of the railways, which happened to be a Government of India public sector undertaking dealing with the funds of the public exchequer. Pausing here for a moment, below the chart which I've just placed. Para 45. Such an extraordinary misconduct of the railways during the arbitral proceeding raises several suspicions in the eye of law. This court is at pains to re-emphasize that dishonesty is the cornerstone for fraud, and that the railway's reluctance in leaving evidence, inept cross-examination, non-submission of documentary evidence, etc., does not fall short of actual and deliberate fraud and or corruption which may have taken place in the present case. Pausing here for a moment, below, the parameters of my case is completely different. The magnitude of the claim and the consequent irreparable harm it shall have on the railways and the public exchequer cannot be ignored. There seems to be extraneous considerations at play which are beyond comprehension of this court. In the proceedings before the tribunal, for both the arbitral award as well as the corrections order, the willing silence of the petitioner is too loud to go neglect, and prima facie leads to the conclusion that there is unseen foul play wherein collusion between the parties to the proceedings had led the arbitral tribunal into passing an award which is deeply induced or affected by fraud or corruption or both. Further, I hereby also direct the Ministry of Finance, Union of India, to immediately constitute a multi-member high-level inquiry committee headed by a secretary to the Government of West Bengal, Government of India level rank officer to holistically inquire into the shocking conduct of the railways and its officials, both serving and retired, and other stakeholders in the above-mentioned matter. The committee shall be at liberty to take assistance of central investigation agencies as it may deem fit. The committee is further requested to complete the inquiry and submit a report within 3 months. Although the said order was set aside by the Supreme Court did not restore the award but instead directed fresh arbitration, thereby nullifying the earlier arbitral outcome in its entirety. This procedural course lends support to the petitioner's contention that the claims themselves warranted re-examination and could not be treated as presumptively valid for the purpose of enforcement. It is also pertinent to note herein that the apex court vide the above-mentioned order had observed Justice V. Ramasubramaniam, former judge of the Supreme Court, is appointed as sole arbitrator to adjudicate on the disputes arising under the scheme agreement dated 30th May and 15th June. An argument was raised by Mr. Venkat Raman, ASD, at the bar that the present dispute, which squarely arises out of the foundational contract, thus in terms of the aforesaid direction, this court ought to send the present arbitral proceeding to the learned sole arbitrator straight away. Such a submission, although appears appealing at the first sight, this court cannot lose sight of the fact that the same was done by the Supreme Court invoking powers under Article 142. And an order was passed, was a consent order by the parties. The present proceedings, though arising out of the same scheme, this court cannot, in exercise of powers under Article 226 to 227, grant reliefs, such as referent to dispute for re-arbitration or setting aside the award. Directions of the nature sought as to whether for setting aside an award or for ordering re-arbitration are beyond the permissible contours of this court's jurisdiction under 226 and 227. This court also notes that the application under section 151 raising the effect of the Supreme Court's order dated 25/1/24 has not been adjudicated at all. The impugned order does not record whether that application was allowed, rejected, or kept pending. Such omission affects the decision-making process itself, rendering the order vulnerable on procedural grounds as well. The petitioner had placed comparative statements on record before the learned commercial court, demonstrating the claim period, claim heads, computation methodology in both arbitrations were overlapping and segmented only on the basis of territorial control of risks. These documents were relied upon to substantiate the plea that the claims were not dependent or discrete, but part of a continuous transactional framework under the same investment scheme, giving rise to a prima facie case that the same pattern of allegedly fraudulent claims has been pursued against two different railway zones. These materials forming part of section 151 application ought to have been examined. This court is of the considered view that the application filed by the petitioner under section 151, invoking the inherent powers of the court and specifically placing reliance on the order of the Supreme Court, ought to have been taken up and adjudicated as a preliminary issue before considering the application under section 36. The section 151 application was not merely procedural in nature, but raised a substantive jurisdictional objection touching upon the very enforceability of the award in the light of subsequent judicial development and allegations of fraud forming foundation of section 34 challenge. The issue raised under section 151 application has a direct and important bearing on the nature of the stay to be granted under section 36(3). If the court were to find that the Supreme Court's order in the nature of parallel arbitration coupled with overlapping contractual matrix and identical claim structure disclosed a primary case of fraud or at least serious enforceability concerns, the statutory consequence under the second schedule to section 36(3) would be grant of unconditional stay. Therefore, the decision on the section 151 application was logically anterior and jurisdictionally relevant to the exercise of discretion on the 36 stay application. We are pausing here for a moment here. Please consider whether this is a correct proposition or not. 151, assuming it is applicable, your lordships have always held that 151 is not applicable if there is a specific provision under CPC. Now, if there is a specific provision under 36, how can 151 application be allowed or entertained? But the learned single judge in a very respectful submission did not apply this principle. That when 36 is the remedy and you file a 36 and then file a 151. Because both cannot go together. You have to remain within the confines of section 36. It cannot be broadened by 151. Then if I may read paragraph 65. By deferring and effectively bypassing adjudication under 151 application, the learned commercial court proceeded to impose onerous financial conditions without first resolving the threshold objection raised to enforcement of the award. Such a course of action results in procedural distortion. Results in procedural distortion.
It will not. They have been given chance.
Had the 151 application been taken up, it would have been a procedural aberration. Or arrogating a jurisdiction not conferred by law. Because 151, again, without taking the words of the Supreme Court, is basically a legislative gap-filling exercise. Where legislature did not frame any law, where a 151 application can take care of a situation. Then such a course procedural distortion where the consequence is determined without examining the governing premise. This approach not only frustrates the very object of invoking inherent jurisdiction to prevent abuse of process, but also undermines the statutory mandate that allegations of fraud must receive prior judicial evaluation before any direction for security is issued, dealing with substantial filing control. Well, with respect to this is with respect to this judicially rewriting the process. That you have to first dispose of a 151 application before deciding or taking up a 36 application. Would your lordship not consider to be a judicial legislation? Then we learned so and so. Then please take note paragraph 66. Reverting to the issue at hand, this court clarifies that it expresses no final opinion on the merits of the challenge under section 34, which lies within the exclusive domain of the learned commercial court, the limited inquiry. Before this court is whether the discretion under section 36 was exercised in accordance with law and whether the mandatory statutory considerations, particularly those arising from the provisos thereto, were duly addressed. For a plain reading of the impugned order, this court finds a conspicuous absence of any such consideration. Therefore, this court is of the view that the impugned order suffers from material irregularity, non-consideration of binding precedent, non-application of statutory standards under 36C, and failure to consider pleadings alleging fraud. The order in its present form cannot be sustained. Well, then his lordship will discusses section 34. Willard, I will not waste your lordship's time on that. Then para 69. This court is therefore of the considered view that given the magnitude of the financial exposure, well, this is what weighed with the court. And this is what was the only submission, 1,707 crores. Therefore, do away with all the procedural factors. This court is therefore of the considered view that given the magnitude of financial exposure and the repeated pattern of the arbitral outcomes, I don't know what is the repeated pattern, under the same scheme, between the same parties, it was not between the same parties, warrant introspection within railway administration as to how contractual disputes of such scale are being handled and defended. But after all, the writ court is an extension of a statutory function. Like we had section 10F appeals by the High Court under the company side, which is not there anymore. So when an honorable judge of the High Court sits in the 10F jurisdiction, the honorable judge is discharging statutory functions.
This goes
Now,
against
when a 36(3) court, whether it is the High Court, whether it is the commercial court, they are definitely discharging judicial functions, but in exercise of statutory powers, not in exercise of any constitutional powers. Therefore, when the commercial court, which exercises a statutory power, whether it has done it correctly or incorrectly, when the writ court is sitting in judicial review over it, in my very respectful submission, cannot go beyond the limited jurisdiction of the section 36 code. And again, if it is under 227, as your lordships have been pleased to hold that, to see whether the court was within its bounds, whether within the, as your lordships have held, whether within the precincts of the.
completely goes against L. Chandrakumar, 7 judges. Completely. This submission.
But L. Chandrakumar, with respect, was under Article 323A and B, where the 226 powers were substituted.
In judicial review.
And when
taken away and vested on a statutory forum.
yes,
So that was held that you cannot
take away the judicial review power.
with the basic fundamental
Right.
While doing
Yes. Structure of
the constitution, and yet you have been empowered to do whatever is ordained in this statute itself. Yet a parties has a remedy to approach to 20, I think High Court under 226, 227, but with one rider that it should not go to the single bench, but directly to the division bench of the
Yes.
court. So that is what is the other way.
But L. Chandrakumar principle, there is no forum. Applicability of that principle over here is what is to be looked into. Here it is not a case of substitution by constitutional provisions of Article 226 in certain matters. For example, service matters, land matters, etc. The Supreme Court felt, as fallen from your lordship, that powers of judicial review of the High Court is the basic structure of the Constitution. How can you take it away?
Right.
Therefore, the Constitution bench restores the power of judicial review to the High Court before a division. We are not in such a situation because here there is a legislation. This legislation does not curtail 226 powers. Here, this legislation, is laying down the mechanism in a party autonomy system, where the parties decide that in case there is a dispute between us, we will not go before the court, we will go before an informal forum and get our dispute decided. And then the ancestral law came, and our 1996 Act is a virtual copy of some differences here and there. Therefore, L. Chandra Kumar principle emanating from substituting the High Court's power and then by the legislature and restoration of judicial review by the judiciary to the High Court, in my very humble submission, would not apply.
That is one limb. While saying so, 7 judges, which is followed 3 times now by the Supreme Court, starting from Madras Bar Association, have very clearly said even a writ petition against a statutory provision, no constraints can be prescribed while exercising constitutional jurisdiction. You can't use a statute to prescribe a constitution. That's the second limb of Chandra Kumar. My friend is laying emphasis on the first limb.
These have all been said in Dwarkanath versus ITU. Wherever there is injustice, the High Court's powers are there. These are nothing new. The fundamentals have been laid down. Any injustice anywhere, the High Court will interfere. But today, those parameters are inapplicable where it goes through a judicial scrutiny. Where I am not, or my learned friend did not come before the High Court under 226 against, say, mines officer's order. It's not that. He's come up against a judicial officer's order or a judicial order. Even now, Millard, as I was saying on the last occasion, Millard, the dispute as to whether Section 11 order is an administrative or a judicial.
That has been set at rest now.
Yes.
Konkan Railway, running constructions, those where the line of judgment says is an administrative amenable to be challenged.
In the 226, in fact, we did so. Before Justice in the Calcutta High Court, we have challenged an order before Justice Girish Gupta sitting in single bench. And that question arose.
In civil lines, we call it incustorial. In criminal, we sort of whether sanction should be. All this is well settled. We are not on that. This has adverse consequences, then it will cease to be an administrative. That's what the Supreme Court has drawn the line. That breaches administrative reasons and goes for affects, and then it becomes.
That is what is being said there.
But in these kinds of cases, the parameters of appeal does not apply. That it is a continuation of the original suit or the original proceeding, everything gets open before the appeal court. Here, the lordships have formulated the only parameters or the exceptions that are applicable. Therefore, L. Chandra Kumar, Dwarkanath, these principles would not apply because this is a specialized form of adjudication of disputes, and the limited extent of judicial review is to be looked into. But I say there is a fraud. My other side says there is no fraud. The judge hence there is no fraud. Please consider, Millard, whether says fraud or says no fraud, whatever it is. Whether, Millard, this finding on fraud, negative or positive, could be, Millard, questioned in a writ jurisdiction. My respectful submission would be no. Because in order to dislodge this finding, the writ court has to go into facts. Otherwise, these findings cannot be dislodged.
Yes.
That's why your lordship has said fraud has to be pleaded and proved.
Yes.
Then, Millard, para 70. This court therefore considers it necessary that the review authorities undertake internal review of these are with all sermonizing. I don't want to read those. Yes. Then, para 71. This court feels that it may be expedient that an SOP so framed may also contemplate fixing up individual responsibility on officers entrusted with handling of arbitration matters, including those tasked with supervision of legal strategy and evidence management. While policy formulation lies within the executive domain, accountability at individual level is integral to deterrence against the systematic failure where financial liability arises due to demonstrable neglect, deliberate omission, or repeated disregard of established procedure, the question of fastening administrative or financial consequences or on responsible officers may deserve consideration by the competent authority. This is not a sermonizing jurisdiction. How the railways will frame its policies. Such measures, if thoughtfully structured, would not only protect public funds but also reinforce institutional discipline. On the other hand, this court is fully cognizant that such dereliction of duty of public authorities may or may not be due to external influences by the private parties concerned in the arbitration proceedings. It is time that, kindly similar the harsh steps that the Honorable Court is proposing, it is time that perhaps appropriate investigating agencies such as CBI look at these cases, such as the present one, suo motu, so that the interest of public exchequer is protected and any recalcitrant parties is not allowed to ride roughshod over sacrosanct mechanism, that is arbitrary proceedings in the country which impact national exchequer adversely and to
imbue sense of responsibility.
Responsibility publication rules first. But with great respect, without an FIR investigation will be made by CBI and suo motu. These powers are not available under section 154 of CRPC, and I think now it is 163 or something. The criminal law has to be set in motion by a victim or some other informant. And why CBI? Again, substituting the normal process. It's all investigation is a state subject. Law and order is a state subject. Why should it go before the CBI? Just because it is railways. Under the federal structure, that is why Section 6 of the Delhi Police Establishment Act provides for sanction by the state. Of course, the constitutional courts can substitute that. That's a different aspect. And then his lordship has been pleased to unconditionally state. Now I'll show from the pleadings not a word of fraud. I do not know where from the Honorable Single Judge has
According to you,
yes, sir.
I must be very specific. According to you, you wanted to impugn this particular impugned order on 3-4 grounds. The first ground is that exercise of judicial power of judicial review under Article 226 against any judicial order passed by a civil court is not permissible nor entertainable. The first line you have dropped. Second line of argument is that even if the court interferes, then there are certain conditions which have been put into Section 36(3). And once the judicial review is restricted to a decision taken on Section 36(3), the entire consideration must be restricted to the nuances or the applicability of Section 36(3) and not anything beyond 6. Second, the third line of an argument which you are making is that once the plea of fraud is taken or projected as a point of attack or a defense, then there should be the pleading which should be elaborate, lucid, explicit so far as the element of frauds are concerned. Mere use of the word fraud in the pleading does not absolve the person alleging fraud to give a particulars thereof in view of this. Therefore, the another point which you are taking is that the writ court should not have converted itself into a court of an appeal to test the order of or test the judicial order passed by a civil court and then enter into deep enter deep into the aspect and then arrive at the conclusion whether the order is sustainable or not sustainable. And the last line of an argument, according to you, is that so far as these directions, or for CBI and all these inquiries are concerned, it was absolutely beyond the scope of the gamut of dispute, and without following the procedures which are provided in the criminal laws, the court should not have usurped the power and decide. Last argument is that simpliciter setting aside the order of the High Court in another proceedings between the different parties, maybe in relation to a same scheme or the agreement, and substitution of an arbitrator by a Supreme Court on consent cannot be a ground to perceive the fraud which has been played in the instant case, as fraud is essentially a mixed question of fact and law, and therefore the fact parity has to be seen before a court jumps to the conclusion on the basis thereof. I think this is
So
what...
these are the points. I have an ancillary point which I have not yet urged. Is that it is also, what should I say, avoiding or bypassing the statutory scheme. Why? Because Section 37 is there under the Arbitration Act. Section 37 has its limited scope, like Section 934 and no other. When it provides and no other, therefore the remedy of the petitioner not being available, the only remedy is under 136. Again, this is a statutory scheme. You cannot bypass or create a forum of adjudication by way of running to the writ court. If that order is bad, that order would have been challenged under 37. 37 does not provide that window. Go up.
Any further judgment you want to?
Because not as such.
Please go. Can I come and slow?
Was this judgments which were rendered by this particular bench
No,
cited before the court?
not this.
No, not my law.
Not this.
We have to say that. Yeah, both of us didn't. Well, at least I was not aware of it, to be very honest.
No, it was not. I will not mislead the court. What was not placed, it was not placed. We live to learn.
Yes?
We live to learn.
Huh?
Can I come and slow?
Yes.
No, I just will not take your lordship to some pleadings. There is no pleading of fraud.
No, that will say that is what I say. That
Yes, your lordship has consummated the fault.
now question is, again, the question is that once the commercial court has said that there is no pleading of fraud in the writ jurisdiction, the court has come to a finding on the basis of the pleadings which has been made in relation to a fraud.
Right.
So one has to simply find out
Yes.
whether there was any pleading in relation to a fraud in an application filed before the commercial court
Yes.
under section 36(3).
Yes.
That's the only thing.
As well as in the writ court. In the writ petition also.
Because they cannot read new things in the writ petition and then talk about it. They can't.
Right.
Absolutely.
So that we will go through that petition.
Right.
Can I start one sentence before lunch so that I will continue? Otherwise, tendency of any counsel.
Let him first say that I have concluded.
The reason why I'm asking is that tendency
Have
of
you?
continue after lunch also to the whole day.
Yes. Now you can say one sentence.
One sentence so that my friend doesn't come back and say 2:15. I want to continue for one more day. Purely the lighter way.
Also, one sentence to stop me.
We always do it in Supreme
Well,
Court.
it's like putting one question in cross-examination and then asking for a
For a deferment.
I'll just formulate two things so that I'll come back and elaborate it in lunch. But all these 6 questions will stem from one important jurisdictional aspect in this case, which is the path which both of us fought very vigorously before the learned single judge, which he has deliberated extensively in his judgment. What is that path? Lord, we concede to the fact without a doubt, fraud has to be pleaded, fraud has to be proved. No doubt about it. But for every golden rule, my lord, there is a golden exception. What is the exception in this case? My lord, fraud vitiates any solemn proceedings, more so before a court.
True, there's no doubt about it.
Now, what
Right from Lazarus Street judgment of the English. I think that's the first judgment.
foundational principle, fraud vitiates everything. It goes to the root of the matter. So, my lord, the first point, the only emphasis I will make, I'll elaborate it after lunch. The assumption of my friend, the reiteration of the senior again and again and again to say that they are two distinct elements, they are two distinct contracts, persons, absolutely wrong. That's where the whole matter and the enterprise has to collapse. Lord, it's a mirror proceedings. How do we say mirror proceedings? Originally, this very same respondent, who is supposed to be the alleged supplier, Rashmi Metallics, not the respondent here. Sir, I'm being disturbed. Can you please? Thank you. So, the original respondent, Rashmi Metallics, entered into a contract with Southeastern Railways. Did not build that location and wanted to continue the service contract. So this very same contract, very same, not some other contract, some other party, same contract was reassigned to East Coast. And for the period spent with Southeastern Railways and the period spent with East Coast Railways, 2 simultaneous arbitrations arose for consideration. Underlying contract is the same. Underlying supply is the same. Underlying supplier is the same. With this, my lord, I'll start after lunch. I have something more to reveal, which I will reveal it post-lunch, if your lordship permits.
Okay.
Extremely obliged for it. It was an enlightening morning for a lawyer who wants to learn, my lord. I think there are many youngsters who would have learned so much today from your lordships.
No, not it. It is also, as he said correctly, we live to learn. So every time, every day, every moment, we really learn.
Lord, I have a prayer, Lord. I need to go back today, Lord. I need to go back today. There's a 4 o'clock flight only available for me. There's a 4 o'clock flight only available today.
My friend can't, then he has to allow his junior to be there 30 to 40 minutes, but he has taken 3 hours. At least I need 30-35 minutes. I'll try.
No, I was suggesting if it could be on some other day.
I completed today, my lord, because we have a lot of concern. We have the last few weeks in Supreme Court loaded with too many. I'll complete it today, my lord. Please give me that 40 minutes. My friend should, or else he should have cut short his and then given me the time. Had he had this plan, I will take 40 minutes. I'll close by the time. Go by the clock. Extremely obliged. Extremely.
Lord, we may be accounted because whole day that is going this sort of day. We have not taken our lunch with hopefully that it will finish up.
We will also not take lunch. Where is DSG? Connect him.
Is not available in this. There is pink in Bangalore. Just one pink card.
What sir? Start code on.
Oh, yes.
Yes, yes. Yes, sorry. Yes. May I please your lordships. Am I audible and visible here?
Yes, yes.
Yes, yes. Lord, just 2-3 facts to show and then findings, and I'll close it, Lord, within the allotted time. So I started by saying, Lord, the origin or the foundation of fraud is common both to the two awards, because 4 factors are undisputedly common. The party, the respondent, Rashmi Metallics, and the signatory on the other side, the Ministry of Railways, are one and the same parties. Only thing, the 2 divisions vary. First, it was Southeastern Railway for a period. Then it got assigned to East Coast Railway. What is in your lordship's court is East Coast Railway. What was before the Calcutta High Court was not Southeastern Railway. So, contracting parties are one and the same. 2, the underlying agreement is one and the same.
Yes.
3, underlying claims are one and the same.
Yes.
Underlying claims are one and the same. Loss of freight rebate due to non-receipt of rates, interest loss due to non-receipt, and loss of profit. Everything is illusionary, imaginary claims, because no supply has happened, no service has happened, because they only brought the rats, they never built the station. So, Lord, this is all loss of profit. Your lordship knows it's all, you can add it to any infinitum, saying this is all my loss of profit. So, all the 3 claims are one and the same between the 2 arbitral awards. So, fourth importantly, it is not as though fraud was proved in the Calcutta Arbitration Award and fraud was not proved in this arbitration award. No, not at all. My lord, this shook the judicial conscience of 4 constitutional courts on their own. This is the history of this case. It's not that my friend went and proved fraud in one case and we proved fraud in one case and got an award. No. The single bench of the Calcutta High Court, the division bench of the Calcutta High Court, the Honorable Supreme Court, and the single judge of this court, 4 constitutional courts' conscience rudely shaken on their own. So, the pattern of this case has to be understood as an exceptional case, my lord, where why the Supreme Court has appointed, my friend says, order on the division bench has been set aside. Absolutely not a right statement. The High Court has not, the single judge has not got, this was argued like that in the single bench did not agree. He said, set aside for what? Set aside for 2 reasons. For a re-arbitration, so that everybody gets a fair opportunity to prove fraud. Everybody gets an opportunity to prove fraud. I'll take step by step. I'll close it within the allotted time. And the most important aspect is, my lord, what was argued before the learned single judge, which weighed, my lord, in the judgment. Now, my lord, they are using this as a jettison to stop and, my lord, annul virtually the other arbitration. Because they will say, this has been now held to be not a fraud. This has now been going on. Therefore, this is similar to that. Same contract, same transaction, same parties. So you will actually try to roll off and collapse that arbitration. That is why we said everything should go before the same arbitrator. That was our plea, which we will reiterate. That we succeeded. Therefore, there was no need for us to file an appeal. 1964 Constitutional Bench judgment. Well, therefore, now, my friend, if he says 151 is an aberration, I will join issue with him. Therefore, please refer it to the same arbitrator, is what we are going to finally conclude. These are going to be the 4 points, my lord. So let me show, it is in this background the first judgment of the Calcutta High Court came to be delivered, which your Lordship will see. My Lord, we'll give all the three judgments, my Lord. Single judge order. My Lord, Mr. Parik, can you give the copies? Single judge, division bench, and the Supreme Court. My friend read a portion of the single judge and went directly to the Supreme Court. Please see the structure. What bothered the court was that nowhere, it's not that in one case our fraud was proved, in another case fraud was not proved. The court smelled fraud. The court felt fraud. Therefore, it will not decided to pass these orders. Sorry? I was told that every copy is given. Yeah. Can you?
Yes.
Yeah.
Single judgment of MS
Judge, division bench, and
Yes.
And not only not identical claims, almost identical amounts. 1,700 crores, 1,500 crores, all put together, 3,000 crores of public money is what is getting involved. My friend cannot prevent me from mentioning the amount because that's the underlying fraud which 4 courts have found it to be prima facie. So, Lord, please come to the analysis, which is Lord, page 33 of the 52-page judgment. Yes. Lord, in paragraph 21, the court takes the assistance, Lord, to define what is fraud. And in paragraph 25, it chooses to define corruption. It's a very detailed judgment, 53-page judgment. 21 is fraud, 25 is corruption. Then, my Lord, in 27 it frames. Now the observations which have been elaborated above indicate 2 separate situations of collusion and foul play, and to the mind of this court, prima facie seems to be a direct consequence of fraud and corruption in making of. This is how the court has proceeded. It's not a pleading case where you plead and then you argue. No. The court applied its constitutional powers and applied its mind to come to this conclusion. And my Lord, firstly, in the arbitral proceedings, the absolutely appalling conduct of the SCR in defending claims upward of rupees 4,000 crores. Here, not only did the railways not produce any witness of its own, but also failed to present any documentary evidence to contradict the arguments put forth by the claimant. The ludicrous cross-examination of claimant's witnesses screams of surreptitious connivance between the parties, wherein it had already decided that railways must abandon all its leverage in favor of the other side and superficially continue to fight an already lost battle under the aegis of an incapable generals coupled with unguarded defenses. So this is not out of pleadings. It's a finding by a constitutional court. Then, my Lord, secondly, my Lord, I'll skip that. Then, my Lord, may come to paragraph 33. Paragraph 33 of 42 or 52, wherein, my Lord, the conduct was dealt with. Conduct of the parties, not based on pleadings. It went through the award, and the Constitutional Court has all the discretion. On its own, it comes to this conclusion. In the present case, with respect to the conduct of the parties, this court observes a disconcerting trend where the hallowed principles of honesty, integrity, and probity seems to have gone up in smoke. It shocks the conscience of this court to observe railways in defending a claim decline to present any witness and refrain from leading any evidence. Subsequently, in the arbitral proceedings, the lackadaisical and indifferent attitude of the railways during the cross-examination of claimant witness, as also noted in the arbitral award, leaves much to be said about the sordid state of affairs, an absolute apathetic approach of the railways, which happens to the government of India, public sector undertaking dealing with funds of public sector. Now to say, I have put one witness, we have asked 400 questions. Lord, it's not the question of bandwidth. It's a question of underlying approach of the same contract between the same parties. The only difference is different arbitral tribunals. Otherwise, it's the same. Then, my lord, please come to 35. Such an extraordinary, now it deals not with one division of railways, it deals with the ministry as such, the railways as such. Such an extraordinary misconduct of railways during the arbitral proceedings raises several suspicions in the eye of this court. This court is at pains to re-emphasize the dishonesty in the cornerstone of fraud and the railways' reluctance in leading evidence, inept cross-examination, non-submission of documentary evidences does not fall short of actual and deliberate fraud and corruption which might have taken place in the present case. The magnitude of the claim, the consequent irreparable harm it shall have on the railways and public exchequer cannot be ignored. There seems to be an extraneous consideration at play which are beyond the comprehension of this court. Similarly, the ridiculous explanation provided that, my lord, I leave it. Then, my lord, may come to 42. While I am in complete agreement that award debtor should not be made to suffer an award obtained by way of fraudulent concealment of material evidence by the award holder, I ask myself whether this is indicative of the only possibility of an arbitral award being obtained by deliberate concealment or suppression. With great humility to the eloquence of the learned AG, I am of the contrary view that given that fraud has a very wide connotation in legal parlance, it is egregiously absurd to suggest that any award which may be fraudulently obtained is limited and restricted to above instances cited by him in the preceding paragraph. The court cannot overlook fraud being perpetuated in the making of the award by way of a collusion between parties. In any event, as at this juncture, this court is not coming into any conclusion on setting aside the arbitral award. The case was cited by so-and-so can be comprehensively considered by the court at the stage of adjudicating the 34 application. So underlying 34 was at that point of time pending. My lords will bear that in mind. Why Supreme Court came to pass that order. Then, my lord, finally, paragraph 48. Paragraph 47. It invokes 36(3) as very much the commercial court should have done. For the reasons discussed above, using the power conferred under section 36(3) of the Arbitration and Conciliation Act, this court grants an unconditional stay on the operation of the arbitral award dated so-and-so, read with correction dated so, pending disposal of the challenge under 34 of the Arbitration and Conciliation Act 1996. Furthermore, I hereby also direct the Ministry of Finance, Union of India, to immediately constitute a multi-member high-level inquiry committee headed by a secretary to the Government of India level rank officer to holistically inquire into the shocking conduct of the railways and its officials, both serving and retired, and the other stakeholders in the aforementioned matter. The committee shall be at liberty to take assistance of a central investigating agencies as it may deem fit. The committee is further requested to complete the inquiry and submit a report before this court within 3 months from the date of its order. So this is how it culminates. But they took it on an appeal to the division bench. And division bench stayed only para 48. My lords will see the division bench judgment. It's a very short order, my lord. I will just read the last 2 pages, last two paragraphs. We shall be able to decide whether the court at all had jurisdiction to pass such an order only upon hearing the appeal. Till disposal of appeal or until further orders, whichever is earlier, the direction in para 48 of the impugned judgment and the order for constitution of a multi-member high-level inquiry committee and to complete the inquiry and submit a report before this court within 3 months from the date of this order shall remain stayed. However, we make it clear that the section 34 application of the railways may be heard of. Mr. Mitra once again reiterated that his client is at the moment not interested in the execution of the award. So there they are not interested in execution. Here they are interested in recovering the money. We also observe that the Honorable Court hearing the section 34 shall not be guided by any of the remarks of the learned judge in the impugned judgment, an order as tabulated in ground 3 of the memorandum of appeal. Nevertheless, we also make it absolutely clear that all grounds available to the railway to challenge the award, including fraud and corruption, if any, as made out in 34 application are open before, even though not in the original arbitral award. The learned judge shall consider those grounds as grounds of challenge to the award. We expedite hearing of the appeal as the respondents are represented by the learned counsel. Issuance and service of notice of appeal are dispensed with. Advocate on record is directed to file an informal paper book serving copy upon them so and so. This is the appeal for 11th October. Stay application disposed of. All affidavits are in. So, only para 48. No other observation or findings are considered to be stayed. Therefore, my lord, the party went to the Supreme Court. And please, my lord, what the Honorable Supreme, it's not setting aside the order, just like that, simpliciter. It is not a regular concession or a consent order for what? My lord, a 34 is pending. They have an arbitral award in their favor, which they are giving up. It's not a consent in its normal or a concession in its known sense. Please see, my lord, delay control. The following order ensures with the consent of Union of India and so, by consent of parties, the arbitral award dated so and so, which is pending in 34, and the order dated passed by the learned single judge of the Calcutta High Court and the impugned order passed by the division bench are set aside. The arbitral award, which was not before the Supreme Court, which was pending in 34, stands set aside by consent. That is the kind of consent. My friend cannot say, set aside, every order. No. What is not before it, it chooses to set aside. Why? So and so, former judge of the Supreme Court is now appointed as the sole, it was 3 arbitrators in both the tribunals, my lord. Now it's a sole arbitrator to adjudicate on the disputes arising out of the wagon investment scheme dated 30th May 2007 and 15 June. These are the two schemes under which this arbitral award has been passed. What is in your lordship's court is under the very same arbitration between the same parties, except there are two divisions of railways. Two divisions through an assignment. The sole arbitrator shall conduct the arbitral proceedings afresh, bearing in mind the stage which was reached before the earlier arbitration. The parties would be at liberty to supplement their pleadings with such additional pleadings as they seek to file within the timeline set by the arbitrator. The parties will be at liberty to adduce further evidence and to seek a recall of any witness who has already been examined for the purpose of cross-examination. The seat of arbitration shall continue to be Kolkata. The sole arbitrator would be at liberty to fix the venue of arbitral proceeding in consultation with the parties. The sole arbitrator shall fix the fees, etc., etc. So, it is not set aside like as though Malad, he has won the case. He's portraying it that way. It's a set aside against his interest. Going back, start from the scratch, file your pleadings, recall witnesses, it's a fresh arbitration. So, Malad, when the very same agreement between the same parties, 3 courts consecutively has found out to be, my lord, a possible case of fraud, and therefore remitted it for by fixing it before one sole arbitrator, examining the very same agreement. What is wrong in our pleading? In your lordship's court and also before the learned single judge, which we did not agree, because the learned single judge only felt that was an order passed under 142. Can I do it under 220? That was the limitation. But we are now, the point is this. No doubt it's a 142 order, but it's between railways and the same party. It is Rashmi Metallics and the Railway Ministry. So what? There is no difficulty in following inter-parties order of 142 by a constitutional court. That does not in any manner bar it. Therefore, in the facts and circumstances of the case, but we can't allow one commercial court, my lord, several layers down, to not decide this independently as a 34. When the other 34 stands already set aside, the order stands, arbitral order stands set aside, and the trial is going on. And the original proceedings are now commenced. And not the sole so one sole arbitrator is deciding the same contract. Why should a commercial court be deciding the same contract? It's all, my lord.
So one thing which troubles me, let us go by the tenet of this judgment and let us presume that yes, there is already a decision taken by the Supreme Court where a sole arbitrator was again appointed. Now, question is that these are the 2 independent arbitral proceedings which were decided by the arbitral tribunal. Now, once you have approached under section 34, what the 34 court may do, there are two options which is available, three options rather I would say available.
Get it?
One is either it will interfere with the award and say that the award is hereby set aside. He cannot go beyond that. Second, he may dismiss section 34 application saying that I do not find any grounds for interference.
Correct.
Third, there is a gray area. There are debatable points whether the remand can be made by a section 34 court. Because I find some judgment says you can't remand it, you have to decide it. Anyhow, these are the gray area one can think about it. So far as the substitution of an arbitration is concerned, can it be done under section 34? I believe not.
Yes.
34 court does not loath with that power to do it, what the Supreme Court under Article 142 does.
Absolutely.
Now, then what would remain? Then let us see. Then what would remain? Testing a particular award on the envelope of fraud, the corruption may at best lead to a setting aside of the award.
Correct.
But the remedy which is provided for a de novo,
Correct.
that remained closed in this fora.
Therefore, Lord,
So now what is to be done?
therefore, my Lord, I'm not, we can't have a better question in the whole proceedings. I'm guided by your Lordship's question. This is precisely the question we canvassed before the learned single judge, which we will canvass it again in your Lordship's court. But see the scenario, anomaly in the scenario today. When the same contract between inter-parties the same.
But the difficulty is kindly visualized so far as that contract is there. Now the matter becomes sub judice because of the Supreme Court order.
Therefore,
Now once all the orders are set aside, not of the single bench order, but also division bench order staying a portion of the judgment of the single bench.
correct.
But the Supreme Court has proceeded to set aside the award also,
Correct.
exercising the jurisdiction under section 34. Can you visualize? But did not stop there.
Correct.
It says that no, I think the dispute is still live. It has still, I would say, the soul and the spirit to go into it, and therefore directed that you adjudicate. That
Correct.
means the claim has not been rejected as of now.
No doubt, no
That
doubt.
needs to be adjudication. But
also
in the instant case, what would be the fate? I am just asking what should be the fate.
Yes, but may I, my Lord, assist whatever.
If we proceed simpliciter on the basis that the court has set aside the award, court was conscious that there has been an element of fraud that is there, then in that event, in particular arbitral proceeding which is directed by the Supreme Court, you do not know what will be the fate.
Yes,
Either the award may be passed or the claim may be rejected.
correct.
In the event the award is passed,
We'll have
Then-
I'll put it this way. I'll answer all the three questions. I'm most guided. But see what we are looking at and how we can mold the relief under Article 226.
Yes.
Very, very important. Today, what is the status of the lists as we understand it? We go to that route, my Lord, we can possibly find the answer. Supreme Court has said this contract requires reconsideration and a fresh opportunity for both sides. Not a conclusion of fraud either way.
no.
It says what under the reason for setting aside is because, my Lord, it wanted to give a clean opportunity to every part. But the reason is because they only appealed. We never appealed. They were agreed by the order and they went to the Supreme Court. And they invited this order saying that my Lord, it's an order against them. Or why do we say it's an order against them? Their order of arbitral award, which was in their favor, stands set aside. My friend cannot overlook the fact. They go to an appeal, get an order against them because the arbitral award now goes. Nothing stays. It is from the scratch. So and today it is not a three-member arbitration there or an award. The Supreme Court finding, my lords, that something could be this or that. Exercises 142 power. It nominated an arbitrator. It's not a section 11, as my friend was procedurally trying to construct. So, my lord, it might be a consent. That is my friend cannot refuse a consent here. That is my case. That is what I argued also before the learned single judge. having given a consent, it's the same party, my lord. How can he play hot and cold?
No, that is what I'm saying, that what would be the fate?
Yes.
What would be the fate and what would be the jurisdiction to be exercised by both 34 court and the High Court?
Yes,
I'm just asking this. Give me a solution. No
Sir,
problem.
my lord, am I not right in pleading in your lordships, my lord, to avoid, my lord, a situation of chaos and legal anomaly? We should avoid that. My lord, a constitutional court can always mow the relief. Can we therefore say, don't get good, my lord, the path took by the learned single judge to say that was under 142, this is 226. I will only seek a limited molding of that relief. No doubt it's a 142, but it's between the same ministry and the same party. And under the same contract, and the same proceedings. One is, it eventually became two tribunals. Now it can always be one because the underlying contestants are one and the same. Ministry of Railways vis-a-vis Rashmi Metallics. Nobody else is a party to this. Two divisions of the same ministry. Therefore, when parties contract and everything is before now one Supreme Court retired judge going into the matter, will it not be, my lord, a matter of convenience for all of us? Nobody's left, my lord. Your lordship, bottom line is
You are saying if they agree that they agreed before the Supreme Court, there is no fetter on our part on the basis of a consensus to refer this matter also to the same arbitrator. But the difficulty is if one of the parties is not agreeing or he has not given a consent, then what? I am just asking you that what is the role of the court? Let us proceed. What is the role of the court and what a relief or a remedy the court can provide or give? Suggest us.
Straight away I'll answer that question. But that's my friend. Do we have now a choice? That's the question your lordship can frame and address. When, my lord, for the same contract and party, Supreme Court has declared what is the process here. Does it not bind both of us? When it binds both of us, can we at all argue to the contrary? This is exactly what we argued before the learned single judge, which we wanted to argue. So can now parties wriggle out of what is binding on them and make out a case on their own theory? I have said this, I have asked this many questions, he was there, he was not there. How does it all matter? When, my lord, documents are insufficient, inadequacy, same claims, but can you say one same claim, one arbitration will go because Supreme Court has interfered, whereas same claims, another arbitration will go to the 34 road and commercial court has the wisdom to this. But complete chaos. And you will use this there and you will use that here. Why?
I think this may be under that particular scheme agreement.
Yes.
But it relates to two different, I think, the Department of the Railways.
Put it this way, my lord. Two divisions.
Two divisions. Now I am just simply asking that whether there would be the same set of witnesses or there will be a different set of witnesses in both the cases. Tell me.
May I put it this way, my lord? The underlying transactional details and the underlying claims are identical. The people who handle the divisions may be different. I'll answer it very clearly. But the underlying claims, Lord, I would say match to match. Sentence to sentence, they match. Lord, please see para 62, 64 of the High Court's order. These are the three, that is exactly precisely what we are trying to have. Only three paragraphs the High Court will learn a single judge order. I would refer it at this moment, Lord, for your lordship's kind consideration. Please come to para 62.
No, High Court has simply left. Now the question is very limited here, but it appears that it has really a far-fetched consequences or a far-reaching consequences. We are the single bench was simply concentrating on an issue whether the section 30 of the commercial court was justified in putting a condition while passing an order of stay of the arbitral award. That was the only question that can only be addressed on the basis thereof, on the basis of section 36(3). The court has held no. It is a fit case where it comes under the exception B, and therefore I think that unconditional stay should be granted.
Correct.
Now, in an appeal, we are simply concentrating on that whether it was really a case which comes within the peripheral of B, or it should be, there was no material to arrive at the conclusion of B. Now, the difficulty is because the consent order is not a law declared by the Supreme Court. Can you visualize? There are two aspects of the matter. Consent order, he may give a consent in one aspect, he may not give a consent in another aspect. May I take an analogy from there? There may be a multiple issues. Parties have been relegated to a mediation. Mediation is one of the alternative dispute mechanism like an arbitration, where the parties may resolve their dispute, amicable solutions may be arrived. It so happened that there may not be any consensus on, say, other issues. There may be a consensus on one issue. So there is no fetter on the part of the mediator so that the parties may enter into an agreement to resolve that particular issue amicably. And then relegate the parties to the court to decide it. So far as the rest of the issues are concerned. So this is what I feel is that in one case, if something has been done, but does it mean that it becomes binding for all time to come?
I'll answer it, my lord. I'm guided by. Will your lordship come back to the Supreme Court order? I'm guided by this question, my lord. Please come to the question.
I know you are talking. It's dated such and such and such and such.
No, not only that. Not only that.
Not that.
Not only. I have something else to say.
Yes.
Now that your lordship put the question, please come to the Supreme Court judgment.
Please.
Yes, my lord. Please see paragraph 2.
Yes.
What is set aside is not a partial findings of the arbitral award or a direction.
No, as a whole. It would like stock and barrel.
I'll develop on your lordship's question because it's a very pointed question. I'll develop on. But I can understand if the remand is please verify fraud, please examine this. Let the award be there. Then if you want the award, you amend the award. I can understand. My lords are absolutely right. What happens in the application process, as your lordship find an example, with a correct matching illustration. What it does, Lord, two underlying constitutional courts have expressed some view on fraud. Now the court, Lord, there are only two options for the court in Supreme Court. They should have, Lord, rendered a finding on fraud. Now the parties converged, no, don't render. We will go and fight it. Please constitute an arbitral tribunal, set aside the award. The consent has to be understood for what? Consent is not a consent, Lord, in their favor. It's a consent with two layers to it. Layer 1, agreeing for setting aside the arbitral award itself. 2, taking a fresh opportunity somebody, Mr. Leonard AG, it's a request, AG. I'm not able to hear you, but it does. You can switch off the mic and speak to your friend if possible. That's the.
Oh, sorry, I'm so sorry.
Mute your.
Not at all.
How do I mute here? I think.
No. Of course, I don't overhear you.
Now it's all right.
No,
Now it's all right.
No, I'm still hearing you. No problem. So, but maybe put it this way. So, they agree for setting aside the entire award goes. It goes to square one. And my lord, the Supreme Court doesn't stop with that. It permits two more things. That's why I wanted reading. It says the parties would be at liberty to supplement their pleadings because fraud was never pleaded in the first instance in either of the proceedings. Their pleadings with such additional pleadings as they seek to file within the timelines set by the arbitrator. 2, the parties will be at liberty to adduce further evidence and to seek a recall of any witness who has already been examined for the purpose of cross-examination. So, when this is the plight, should I be handicapped in 34 when I have to argue in this commercial court whether you pleaded fraud, whether you have filed this application? Why should I plead? This is, my lord, a finding now on the contract, inter parties, except for the divisions which are different. When one order of arbitral is set aside, the same fate should follow, my lord, when arising out of the same. My lord, tomorrow, either one of us go to the Honorable Supreme Court. We'll have to place the same thing and say, this is what you have done it. So, can we now request the same prayer in your lordship?
Absolutely, you are absolutely correct that the approach can be made to a apex court. The apex court has, and I would say, some extraordinary powers conferred under Article 142.
I have
There cannot be any inhibition, I would say, or a restrictions or any kind of an impediment into the Supreme Court in adopting the same mechanism and the procedure. But the difficulty is the power exercised by the High Court and the commercial courts.
I have only one rider to add, my lord, if it pleases your lordship on this point, and my lord, I'll leave it there. We would not have persuaded it to this extent had we not, my lord, found out for the same party there is a judgment.
Yes.
I'm not on the award A, award B, on the arbitral process.
Yes.
Therefore, it is to the advantage of both parties. We should think that if this is referred to the same arbitrator and a holistic arbitration takes place between inter-parties on the same contract, how are parties prejudiced from
That's a nice suggestion, provided they agree. If they agree on that, there is no difficulty. We can also adopt the same.
My friend obviously will not agree. My lord,
Yes,
because-
Mr.
No, I cannot give up the usufructs of a award. This is what my learned friend
No, I
is
understand.
suggesting.
Now, 1 minute. Now, do we need his second layer? Do we need his consent?
Yes.
Point. Yes.
That is my pertinent question to you.
Yes. Now, my lord, I very respectfully submit. The Supreme Court might have required the consent at the first instance, no doubt about it. Now, my lord, a law is now to say that it is a concessional order may not be under 142 right, but it is.
Put it.
Yes. I'm sorry. Yes.
Oh, I'm so sorry. I'm so sorry. Yes.
Not at all.
Is there any?
No, can we remove that from, or it is
No,
fixed?
I switched this off, but
Then you must be having a mic in your throat, I think. Electrifying mic. Obliged. So
That is what is the, I would say, sometimes the virtual hearing. There's a
yes, this is a
problem with the virtual hearing.
yes, sorry, my lord.
talks, background noises, they come in.
May I say this? Therefore, now we have passed that threshold when it is inter-parties. That is all I'm trying. Is a constitutional court so impaired in saying, no, we still have a constraint in doing this, my lord? At the moment, I have a doubt, especially inter-parties. When everything is the same except for the award given by a different arbitral tribunal, it's a continuous contract. One period A, period B, same contract. It's not different periods. And my lord, the allegations are the same. Allegations are the same. Only founding allegation is that collusion, non-cooperation, non-submission, and facilitating the whole process to ensure that they succeed. This is not the underlying. Yes. And Lord, alternatively, if this is not possible, my lord, then your lordship should ensure that the findings of the learned single judge is sustained, because on merits it is otherwise sustainable. We are only looking at whether we can go back to the same arbitrator.
No, that is why then this another question would come, because what you say, that was when you started this argument, so I put a question to that. Now the larger or basic foundational objection or the point is whether the 227 application is competent against a judicial order passed in a civil proceeding. So that is I think, the most fundamental point we have to address.
I'll answer it in two parts, not straight away.
Yes.
Lord, I had fortunately the lunchtime to go through all the judgments of my learned friend. I have no problem. All of them very clearly, my lord,
including us.
As it pleases. Without a doubt, including us, because it binds.
And still we are open. If you can say that we have committed a wrong, we are ready to accept it. I must be very clear to you.
Well, we can't
because
see
even the judges are not infallible. So I am ready to correct myself. No problem.
With utmost respect, my lord, your lordship need not have to correct it. Your lordship has to whether it's applicable or not. I'm not arguing beyond that. I'm not saying that on that context it is right or wrong is the question. Whether that context exists in my case. Well, I'll put it this way. But one thing is very clear as a foundational principle. Any judgment, all the judgments cited by my friend, always leaves a caveat, always leaves a carve. Every judgment he has read, whether it is 226 or 227, saying that exceptional cases. Because, well, the governing power of, we'll put it this way, legislative power is sacrosanct and sovereign and supreme for the parliament, because we work on the three vertical principles.
True.
Executive discretion and executive policy making is amenable, both legislative law or executive policy making is amenable to judicial review only when it is manifest arbitrary or unreasonable or violative discrimination. Otherwise, policy choice is always the right and domain of the respective constitutional organs. The same power is also given to the judiciary under the Constitution. That your power of exercise under 226 and 32 and your superintending power under 227 cannot be capped or read with limitations, because nobody can foresee the future and the circumstances which can multiply and occur in your lordship's court. So every judgment which says it has to be restricted, it has to be conditioned, always says in exceptional cases. What is so exceptional about this case? Exceptions are twofold. A, fraud vitiates every aspect of proceedings. It's an exception by itself. Two, the same contracts have run up to the Supreme Court and it has gone back, getting the award set aside when it was not before it. That's the power which the court has exercised. An award which was before a commercial court in 34, the Supreme Court said, I'm setting it aside and let parties go and re-adjudicate the matter. So, on the strength of fraud, which the courts have smelt, this order came to be passed by the Honorable Supreme Court. That is the second exception. So, when that exception, my lord, is not different to say, I had X, he had Y, we had this business, we had, all this is not going to cut ice. When, my lord, the underlying incapacity, underlying efficiency, underlying pursuit has not been diligent enough, is what. And my lord, I'm surprised that my friend chose for a few brief minutes to hold the brief of our officers and trying to cover and say that they have been diligent, they have been on. But we don't need that certification, and definitely not in the capacity. But this is exactly the problem. If you try to defend their conduct, you have a problem. This is exactly the problem. Why? Why at all you go and defend? What is the reason for basis for such a defense? When, my lord, Calcutta High Court did not agree, Division Bench did not agree that those portions of fraud and corruption has not been stayed. Only inquiry has been stayed by the Division Bench. It said rest of the paragraphs will remain intact. Go and argue at 34. So the third exceptional reasons. The third exception. One, my lord, it is fraud. Two, my lord, how it has traveled the journey under the same contract. And the third exceptional reason, Lord, learned single judge of Calcutta High Court stayed the award and the flow of money. It went up to Supreme Court, award itself got set aside. So, can't we not rely on the parallel for the same? Therefore, in that light, I will read only 3 paragraphs of the findings of the learned single judge for this order to be sustained. Paragraph 62, 64 and 69. Only 3 paragraphs, my lord. May I be permitted to read only that? With that, my lord, I'll close my arguments. My lords may see paragraph 62, which is, my lord, internal page 90 of the writ appeal filed by my friend. This is undisputed in the entire argument by my friend. Page 90, paragraph 62.
Yes.
The petitioner had placed comparative statements on record before the learned commercial court demonstrating that the claim periods, claim hits, computation methodology in both arbitrations were overlapping and segmented only on the basis of territorial control of rights. The documents were relied upon to substantiate the plea that the claims are not independent or discrete, but part of a continuous transactional framework under the same investment scheme, giving rise to a prima facie case that the same pattern of alleged fraudulent claims had been pursued against two different railway zones. These materials forming part of Section 151 application ought to have been examined first. Please come to Note 64.
Yes.
The issue raised in Section 151 application has a direct and important bearing on the nature of stay to be granted under 36(3). If the court were to find the Supreme Court order in the parallel arbitration coupled with the overlapping contractual matrix and identical claim structure disclose the prima facie case of fraud or at least serious enforceability claims, the statutory consequences under the second provision to 36(3) would be grant of unconditional stay. Therefore, the decision on 151 application was logically anterior and jurisdictionally relevant to the exercise of discretion in 36. My friend says it's a big aberration. Why 151? You should have extended under 36(3). No problem. You do it under 36(3) itself. You read that 151 as an application of stay under 36(3). No difficulty at all. Or else, can I put it this way? We'll avoid that aberration. Can't this not be examined, my lord, by your lordships in para 64? What has been said in 64? If, my lord, and my friend has not contested it in any manner that they are different claims. This is claim A, that is claim B. The claims are all different issues. Not at all. Not at all. He has not spoken a word about it. And, my lord, please see, I'll close it with that. Then, my lord, please come to one last paragraph. And, my lord, please see, my lord, paragraph 66. At 92, middle portion. Therefore, this court, I'll just read that, my lord.
Yes.
Yes. Para 66, middle portion. Therefore, this court is of the view that the impugned order dated 2/9/2025 suffers from material irregularity, non-consideration of binding precedent, non-application of statutory standards under 36(3), and failure to consider pleadings alleging fraud. The order in the present form cannot be sustained. So, my lord, can't this not now be, my lord, examined by your lordships, and, my lord, a similar relief can it be granted? Having the entire circle, including the presence of so and so, this is the panel. Now, please see 67. Having regard to the entirety of the circumstances, including the pendency of the challenge under 34, the existence of a parallel arbitral history arising under the same scheme, the setting aside of the earlier award by the Supreme Court, and the serious allegations of non-fulfillment of foundational contractual obligations, this court is satisfied that the prima facie case would have warranty protection and enforcement. Therefore, my lord, can't I not now rely on this and say that the order of the learned single judge can remain? Well, there's no need for interfering with this order or course correcting it. The course correction, if at all, my lord, should be only to ensure that it goes to the arbitration. Otherwise, it need not. And my last point, my lord, is please come to section 36(3).
Yes.
My lord, what does 3 second proviso says, which is exactly what has been examined? It's a statutory connotation of a very, very important principle in public law. Provided further, yes, that where the court is satisfied that a prima facie case is made out, A, that the arbitration agreement or the contract which is the basis of the
New book.
new book, 36(3), yes. 36(3), second proviso, my lord.
Yes, yes, I know.
Yes. And B, the making of the award was induced or effective by fraud or corruption. It shall stay the award unconditionally, pending disposal of the challenge under 34 to the award. So, my lord, this is something arising out of public policy. The judgment of the Honorable Supreme Court in Antrix is a very, very leading authority on this very aspect of nobody can earn the booty or the fruits of an award if it is if the foundation of it is based on fraud, because it's contrary to public policy. So it goes into public policy domain. Therefore, it will constitute an exception. That's the fourth reason. So, Lord, let me answer the questions raised by your lordship before lunch. A, do I come under the exceptional clause? Yes, I do come under the exceptional clause for the following 4 reasons. P. Should therefore a power be exercised to interfere either under 226 or 227, my lords can exercise very much this power because, my lord, the commercial court is in your lordship's supervisory jurisdiction under 227 and under the constitutional jurisdiction under 226. 3. Should fact of fraud be pleaded and proved, this is an exceptional case where courts have sensed fraud.
Just a minute.
Sorry, Mr. Yes.
Yes, Mr.
Yes. And third, should we have pleaded fraud? No, not in this case.
What is your reaction to the first proviso to subsection 3?
Yes, I'll just read. Can I read? Yes. Provided that the court shall, while considering the application for a grant of stay in the case of an arbitral award for payment of money, have due regard to the provisions for grant of stay of a money degree under the provisions of the Code of Civil Procedure. So, my lord, this is again one more leaf available, my lord, to say that the norms of a money degree which are available for stay can also be pursued before, my lord, the 34 court for a similar relief. But that is my lord, a generic.
No, generic, I'm giving you a lead.
Yes, yes.
Can you come to Order 27, Rule 8, capital A?
1 minute, one. Order 27, Rule 8, cap. I'll just take it in a minute.
And we are pleased.
I hope he's arguing in my favor. Then I will agree.
That is what I'm saying. Order 27, Rule capital A.
Yes. May I read it to your lordships and to my benefit of my friend also? No security to be required from government or public officer in certain cases. No such security as is mentioned in Rule 5 and 6 of Order 41. 41 shall be required from the government or where the government has undertaken the defense of the suit from any public officer sued in respect of an act alleged to be done by him or his official capacity. So, Lord, I think ministry is definitely a government, not a PSU. I think Southeastern Railway is part of the ministry and not like Konkan Railway, which is, Lord, a joint venture, a separate PSU. I think Southeastern and East Coast Railway will check up in a minute's time. They are a government entity by itself, directly coming under the Ministry of Railways.
And you come to Order 41, Rule 6. It talks about a security in relation to money degree.
Order 41 rules. May I read it to your lordships, my lord? Security in case of order of execution of degree appealed from, where an order is made for the execution of a degree from which an appeal is pending, the court which passed the decree shall, on sufficient cause being shown by the appellant, require security to be taken for the restitution of any property which may be or has been taken in execution of the degree, or the payment of the value of such property, and for the due performance of the degree or order of the appellate court, or the appellate court may, for like cause, direct the court which passed the degree to take such security. Where an order has been made for the sale of an immovable property in execution of decree, and an appeal is pending for such decree, the sale shall, on the application of the judgment debtor to the court which made the order, be stayed on such terms as to giving security or otherwise as the court thinks fit until the appeal is disposed of.
And then for Rule 5 is the another power which is given.
Yes.
Order 41, Rule 5, stay. Because it first proviso talks about stay with due regard to the stay of.
Where an application is made for stay of execution of an appealable degree before the expiration of the time allowed for appealing therefrom, the court which passed the degree may, on sufficient cause being shown, order the execution to be stayed. No order for stay of execution shall be made under Sub-Rule 1 or Sub-Rule 2 unless the court makes it satisfied that substantial loss may result to the party applying for stay of execution unless the order is made. The application has been made without unreasonable delay. The security has been given by the appellant for the due performance of such degree or order. Subject to the provisions of Sub-Rule 3, the court may even make an ex parte order for stay of execution pending the hearing of the application. Notwithstanding anything contained in the foregoing sub-rules, where the appellant fails to make the deposit or furnish security specified in Sub-Rule 3 of Rule 1, the court shall not make an order staying the execution of the degree. But here the case is, the problem is this. They are asking us, the direction is to pay us, my lord, about 70 crores in cash at deposit and close to 1,600 and odd crores, my lord, securing through a bank guarantee, which, my lord, when in the light of the findings of fraud, as observed, but my friend cannot blow hot and cold. He doesn't have the choice. He is the party in both arbitral proceedings. He cannot say, for there I will give a consent and take the award back, and come here and say, I won't give a consent here. He has no choice. Can he be? If he exercises a wrong choice, the court has that constitutional power to impose on him. You can't do it. If he has not done it at the first instance, it's a different question. He now cannot have a privilege conferred upon him because much water has already flown under the very same transaction, very same agreements against his client. Can they blow hot and cold? Can a constitutional court is so helpless, my lord? That has been my pursuit in this matter, for your lordships to lay down a law. A constitutional court is not helpless. It can't allow a litigant to choose its options when, my lord, it has surrendered itself, its option against this contract. How can it revisit the option? Where is the answer from my friend on that? He can't say because the tribunal is different, he has a different option. The underlying performance is the same. Tribunals cannot decide his fate. It's the contract for which he has conceded. It is the process to which he has conceded. It is the prima facie allegations, prima facie findings of the court to which he has conceded. How can he take a different stand, my lord? This court should not permit.
Yes.
That is, my lord. With this, my lord, these are my submissions at the which according addresses all the 5 questions. It was an enlightening day for us, and I'm sorry to my brothers and sisters for not. It's a great opportunity to be back in Orissa High Court after a very long time. I hope they will. For staying.
No. It is always a pleasure to hear a person like you. Definitely. Yes, that's all.
But 10 minutes is it?
What 10 minutes? Cannot catch.
5 minutes.
You should take your flight.
First is only clarificative, nothing new. First is it is not the same contract.
Which is wrong.
And it is not between the same parties.
Which is wrong. Which is wrong.
Because I have a tool. I have a contract with one of my juniors. That is one thing. And the same tool, I have a contract with Mr. Party.
No, it's a wrong comparison. I have to deny it. At the rejoinder stage.
Therefore, it is not the same contract between the same parties. Okay. One of the parties is definitely common, that is me, because I am the owner of the goods. But for some time it was used by East Coast Railways. For some time it was used by Southeastern Railways.
No. Just I'm clarifying. I'm just clarifying. Lands in the vital.
Correct.
Initially, the agreement was executed with the East Coast Railway.
Correct.
Subsequently, there is another person of work has been constructed with the Southeastern Railway, not a different work, different contract. Out of the same contract, again, once again, it was executed.
Let us clarify things. Let my learned friend show the same contract. The matter will end over there.
There is a doubt.
Please show it to the court. Please show it to the court.
Two different
Please show
contracts.
to the court that the contract is this one.
No.
But with respect, nothing will transfer from them. But my submission is these are 2 separate contracts. Number 1.
Please file an affidavit and
Number
show
2.
evidence. You can't.
Sir, I expect the same courtesy from you.
I understand, but no, in a rejoinder, I have never interfered in your mate.
Yes. Now give me the court is already in short of time because of both of us. Please do not keep the court waiting.
All submission at a rejoinder has to be outpost immediately, my lord. That's the logic.
Whatever let him submit, we will go by the records. There is nothing, we can't
First,
beyond the
it's
record.
not two separate contract, only one party is common.
Yes.
This is number one. Number two is, Milord, the reading of the Supreme Court's order in my very, very respectful submission with due deference to my learned friend is a wrong reading of the order. By consent of the parties, everything was set aside. It is not that the Supreme Court has set aside. Your lordships have held a consent order is an agreement and a command of court. So first, the parties have to agree. Then it is translated into a command of the court. The command of the court that the parties have agreed. Therefore, single judge, division bench, award, set aside. It must go for a de novo arbitration. It is not a decision or a judicial fiat simpliciter.
There. See, what's the
Yes.
My learned friends go up in appeal. I mean, SLP before the Supreme Court, I consent. Number three is the submission that today I cannot withhold the consent because of the Supreme Court order, whatever may be the correct interpretation, your lordships would consider that. But in my very respectful submission is completely a misplaced submission. Because judiciary have never extracted any consent from any party. Judiciary will not take steps only if persons consent. If do not consent, if they do not agree, judiciary adjudicates.
Yes.
Therefore, my lord, my learned friend cannot make a submission that today I cannot withhold consent. I do not know under which principle. Is it res judicata? No. Because res judicata applies in court or on the court, not between the parties. Is it any estoppel?
Yes.
Therefore, my lord, one cannot say that simply because I had consented in one litigation, I am bound to consent in the subsequent litigation. Let us assume for argument's sake, everything is same.
Yes.
Well, please consider from another angle. Had my client not consented, take a situation in which we are today in this proceeding, that before the Supreme Court, my client did not consent. The Supreme Court would have adjudicated and may have done the same thing. Then only it would have become a precedent for the future.
Yes.
And please take it from me, I expected my learned friend to, like my learned friend had read Justice Saraf's order, I expected my learned friend to point out at least one sentence in the section 36 application and one sentence in the writ petition that they had pleaded from. They are not.
No, that is what you are already argued. We will definitely consider.
And Milord, it's a different tribunal. I don't think that this will apply. Rest, Milord, I leave it to the court. There is no exceptional circumstances pointed out by my learned friend, except saying that having consented there, you cannot withhold consent over it. These are my suggestions.
Thank you.
Extremely obliged, my lord.
Make it CAV.
I thank all my brothers and sisters.
Yes.
Very beautiful.
We are really grateful that your interruptions have spent the entire day for this.
At the expense of your brethren fraternity sitting behind.
Right. Yes.
Humble apologies. Pleasure to address this court, my lord. Deeply obliged. Deeply obliged.
So I owe an apology to the members of the bar also.
Yes.
Can I be permitted to exit your lordship? Can I exit your lordship's court with your permission?
Yes, please.
We are grateful.
Item 2.
Petitioners are the villages of Kendrapada, my lords, and they agreed by the construction of a petrol pump under high tension wire, my lords. That because that
Under high tension wire.
yes, my lords. That is because that is the petrol pump is being constructed under the high tension wire. I've given the pictures also. We have filed
Where is the picture?
my lords will find it.
36. Page 36.
At page 36 and 37, my lords.
It's along the side.
No, my lords. It's all over the part of the land, my lords. It's on part of the land. I've given page 36, my lords will find it. It's on part of the
36, I could not
my lords.
decipher anything therefrom. 37 appears to be a clear,
My lords, it is on part
but it appears that it is really
it is on,
along the side. Huh?
Distant place.
That's true.
Distant from.
Correct.
it is on the part of
You take an instruction, make an inquiry, and then submit a report
Right.
that is there. So, the instant public interest litigation is taken out by the petitioner alleging that the competent authority has on him.
see the construction is going at full swing actually. I find I'm not pressing it, my lords. I'm not pressing it. May I pray for a shorter time? Because let them get the instructions and it will my lords. Obliged.
Adjourn to 24th June.
Obliged.
2 weeks. What 2 weeks is not a vacation?
20th May.
So 20th May, keep it before the vacation.
20th May.
Obliged.
Item 3.
Thank you, Your Lordship. Your Lordship is already familiar with that clause in the Works Department contract, which says when there are more than one bill, which is less than 14.99%, it has to be a lottery. There has to be a lottery. Now kindly take page 97. Page 97 shows that there are 7 bills at 14.99.
Yes.
Now, without a lottery, they have issued the LOA
How can it
at
be?
page 98.
How can it be?
They're giving it to 14.999959.
That cannot be done. We have said only two digit. I think our judgment is very clear on that.
That is also the condition that 29 is to permitted. But after 29, another 99.
So it can't be done. It can't be done.
Closer to 15.
No. So it can't be done. It is only the first two digit after the decimal has to be taken.
What they have done, because it's the
It says that for 14.9999999, which is below 15, by all means. Why you are doing it? First two digit.
we have already issued the.
No, sir.
What he says.
You are
That clause is page 46.
Page 46. No, page 46.
2.20.7.
That is there. That is the advertisement.
Yeah. But our judgment is different.
I've seen your lordship's judgment. I've seen that judgment.
So,
Two places.
so if it is more than 5, then it will be added to that.
No, but if it may, then it gets disqualified. It becomes 15 then.
That's true. So you will get disqualified. Others have not done.
Not me. He will get disqualified.
Oh, he is 99999.
Yes.
No, there is a judgment.
I'm not arguing on that.
Oh, you are not that.
I'm not that. I'm 14.992.
Oh, he is a 9 on that.
There is judgment always, rounding up is always for the benefit of the person. Not
Whatever, if it is, there are two aspects.
Yes.
If you are taking only two digits,
Yes.
correct? You are not supposed to take a third digit. Then in that event, whatever is the two digit of the persons, you'll have to take it.
That is true.
If you say that you will also take the other digits, then according to a mathematical precision or the formula,
Rounding
anything
uncorrected.
after the decimal, the third line is more than 5, then it will be added to a preceding integral number.
That is rounding.
And then it will be rounding will be done.
What the lordship is saying,
In
too,
both ways you are wrong.
but the rounding up is always made for the benefit of the person who's.
Oh, I am asking in both ways you are wrong.
Yeah, that,
If you say rounding off is permissible, then it is 15, then he is out. If you say no, rounding off is not, only two integral, then it appears that 7 peoples are there, then you'll have to do a lottery. How can you give a
may it also keep it.
contract or taking a third integral number? How can you take it?
What the lordship is saying correct. I don't dispute on that.
So in both ways, you can't avoid
Let me take instruction because
no instructions. You are saying that a contract has been issued, LOA is issued. We are staying.
Page 90.
We are staying. We are doing.
keep it to
They can't do it. No, this is something which is in both ways you are wrong. So, cherry picking, impartial.
So what I
Sorry, when 7 people have participated, say, quoting the same price, how can you give what a LOA to one?
they are under the impression that after 99,
Then why you are putting a clause of only 2 decimal? Why? You could have said, then infinity it will go. One will write 14.99 plus infinity.
They should-
Now you calculate how much? That's why only 2 digits.
that is also the condition also. That is also in the question.
Where is the clause?
Mr. Vikram
Page
Mukherjee,
46, 2.20.7.
Page?
Page 46.
Page 46. Top.
The second sentence there. But if more than one bit is quoted at 14.99%, decimals up to 2 numbers will be taken for all practical
Yes.
purpose.
Yes.
Less than this.
they have restricted it, not to third.
Not to third.
So arithmetical formula will not,
Counting of no correcting.
the third digit cannot come
This is truncation.
too technical.
Here is a peculiar case. All of them are 4.9990.
No, here it is
Peculiar.
your executive instruction.
Back off.
Let's call the next.
Item 4. Petition the proprietorship for in the business
Proprietorship
firm.
concern,
Consent.
partnership firm.
Yes, ma'am. So proprietorship consent and in the business since last 2 decades, ma'am. But you know, opposite party, the state has come out with the tender notice under Annexure 1 bylaw, wherein your lordship may kindly see I'm aggrieved by the 2 restrictive clauses at page 20, section 2.2, Roman 1 bylaw. But this
Page
is
20, 2.2, Roman 1
yes, ma'am.
shall be registered in India as a company,
Company,
partnership firm, limited liability,
partnership,
but no proprietorship concern.
proprietorship consent.
I
And this
think
is
there is one matter which is already pending previously. Mr. Roth, you moved it. One matter, I believe, when they restricted the participating bidders to the other thing except the partnership, the proprietorship concern.
Maybe
They have excluded the proprietorship concern from the purview of the eligibility criteria. Yes, partnership forms and all, everything is included. Proprietorship concern. So what is the fate of that?
And that notice has been issued, and they are possibly proposing to recall that tender. That part is my instruction. That has not come up yet.
What is the last date?
10th of this month.
How can you proceed? Will you issue the corrigendum that they are also eligible? Otherwise, we'll stay.
Actually, a bit of a fix my assistance aside.
Come on Monday, because it is the 10th is the last day, but you
Monday
take
she may not be able to, or 5th, Monday she may not be able to, because today is Saturday, she may not.
come on
Monday.
Tuesday.
Monday you take instruction. Tuesday.
Tuesday is the 5th. Last date is 10th. So no difficulty.
Adjourn to 5th May. Item 5.
And don't quote the observation of the court. It is all the tentative one. We will change our observation.
Item 5 members, when petition is the lowest tender, you have challenged your retender of your one. Along with the fresh retender notice has already been issued. The fact is, my lord, the present petitioner
Who are challenging the first tender.
has submitted.
Have they cancelled?
Yes. They have quoted that for retender. Thereafter, another tender notice by Annexure 1 has been issued. The fact remains, my lord, Annexure 2, the initial tender call notice that was issued in the month of January it was issued on the tender call notice dated 20th January 2026. It was issued in respect of 15 works. So I am only quoted in respect of serial number 14. So 14 work I have quoted. So in 14 work, and the matter is to be tended to be opened on 17th February. So 17th February I have quoted in my portal. Nothing has been mentioned. But in the clause 9 of the tender call notice, it has been clearly mentioned that it will be portal, it will be online open in presence of every bidder matter. So I noted that they didn't disclose anything. So on April, after 2 months, on 20th April, they have uploaded in the portal. I found at 12:45 p.m. That I am the lowest bidder, that is Annexure 3. There are 15 participants there. So I have quoted 10% less. So they have very categorically mentioned that I am the lowest, that is page.
No, page 21, I have seen. Yes,
page 22, last one. Page 21 is the serial number 3 I am quoted. And lowest amount quoted by John to Kumar there, that is black quoted there. So they have quoted. Admittedly, they have.
Yes, then.
Then, my lord, what happened at the same day at 8:45 p.m. They have uploaded the exact calculation of the tender committee, that is annexure 4, let me see. My work is serial number 14. That is page. That is page 34, my lord. 34. In the page 35, their last day of lesson, the tender committee decided to re-tender the above work. Simply no reason I assigned nothing, my lord. Thereafter, what happened, my lord, when 20th I inquired into their office, there only I can found that 17th, prior to 20th, 17th of April, another notice has been issued, that is annexure 1. My work is serial number 5, my. That is page 10. The fresh tender notice we are telling. 17 for 2022. So, 5 is my work. That was previous tender, it was 14 serial number. So here, my lord, let me see the clause. They have already mentioned that it will be in all. The recipient of online will be opened on 11 a.m. onwards on 17 February 2016. In the office of the PADID Bhajpal, as per available of internet, bidders who participate in the bid can witness the opening of the bid after logging on the site. Here what happened, my lord? After 2 months, they have uploaded the entire calculation sheet of the tender committee. There what happened, there they have mentioned that it was on, bid was reopened on 17/2. After 2 months, they have reloaded and mentioned that it has opened on 17/2. So my aspect of submission, my lord, I have already quoted 10% less. No opportunity has been given. I have been deprived to answer anything because they don't even assign any reason. The committee was given that all tender aspects, how they have calculation. So in my case, they have written only retender. And on 20th, they have already uploaded. On 17th, they have already issued a fresh tender notice, that is annexure 1. Altogether, 15 works are there. Last time I kind of it is annexure 4, that tender committee report. 10 works, all portion has been quoted 0%. And 10 works has been, through lottery has been settled. And 5 works, they have mentioned that it will be retendered. Annexure 4.
Where is the Bhimaka block?
This is my bunch.
No, which serial number of that decision?
My decision is a page 30.
Bhimda, that is the serial number 14
Yes, my lord.
at page 34.
34. 35 they are mentioned.
No. 35 is a different.
Serial number 14. So they are,
You have participated only in this.
only this.
This.
Joint Kumar,
Just wait.
serial number 6.
Madam, there is no reason assigned why you have done. In one cases you are going, and in this case you have not assigned any reason. Why you have cancelled or retender? Sorry, then we are staying the operation of this tender. Last date is on 4th. Okay.
I obtained inspector. This was assigned to learn and she said he had to rush home because of his wife's medical emergency marriage. I was handed over the
But this is the matter where the last date is there on a day after tomorrow. What will happen? Keep it a Monday as a first matter.
Monday they may proceed on
5:30 is the date. Time. Don't worry, I have seen that.
You keep yours ready.
5:30 is the time.
HON'BLE.
Yes.
Adjourn to 4th May, item 6.
Process for construction of staff workers. We are concerned with item number 1 at page 12. Now, the grievance is this, your lordship will turn to page 64, clause 120. It says, the online bidder shall digitally sign all statements, documents, certificates.
Which one? Which one?
Clause 120 at page 64.
Oh, yes.
The online bidder shall digitally sign all statements, documents, certificates uploaded by him, owning responsibility for their correctness, authenticity as per ITF also. If any of the information furnished by the bidder is found to be false, fabricated, bogus, EDMT, which security shall stand for.
Yes.
The
Yes.
registration in the portal shall be blocked and the
Yes.
will be blacklisted. I am concerned with this digitally signed. Your lordship may kindly see the bid that I have submitted, and more particularly, I'll take your lordship to page 104.
Yes.
Your lordship sees at the bottom, digitally signed Jairam Pradhan.
Yes.
All pages your lordship will find the annexure to it my bid document that commences from page 100.
Then you have put a digital signature then?
Yes. Now your lordship may kindly turn to page 292 annexure 6. This is the bid of the OP, who is now found to be the lowest bidder. Your lordship. None of the
290, 296.
So your lordship may scroll through the pages. Your lordship will find none of the pages are digitally signed. He has put a signature and uploaded, not digitally signed. Your lordship says none of the pages.
So that is one of the conditions.
Yes, that is
Yes,
clause
that is a
1.
digital signature.
Now, what they have done in respect of another circle where I had submitted my bid without digital signing, there was a similar clause as clause 126. I have annexed that document. They rejected my bid saying that you have not digitally signed. Now, what they have done, they have now published the list of bidders that your lordship will find at page 99, annexure 4. There your lordship will see he has not been disqualified. Despite whether I have shown to your lordship, he has not digitally signed any of the documents. I submitted a
99.
Yes, page 99. Your lordship.
Yes.
There, my lord, he has been shown to be a qualified bidder, that is serial number 2. Though, my lord, I have shown to your lordship his bid sheet, none of the pages, some of the pages are not signed at all, though all the pages are to be signed, even assuming that's a digital signature, and it's not a digital signature. Now, your lordship sees similar clause was in respect of another circle, Eastern Circle, page 570, where I was a bidder, my lord. Clause 120.
What you are challenging? You are challenging the awarding of a contract to the serial number 2 people?
Yes.
In this,
on the ground.
you have no grievance so far as the other rejection order is concerned?
Well, I will come at serial number 1 if it is verified.
You have no grievance to the other tender where you were your bid was rejected?
Just demonstrating that.
I understood.
Yes.
So you wanted to have, the step over. Yes, understood.
And I submitted a representation. They replied that he has submitted the digital signature certificate. The certificate is granted, my lord, under clause P. It is not, my signature is to be done after that, my lord, pen drive kind of thing is given. He has to digital sign through the help of that. So it is not one and same. So that is the thing, my lord.
Yes. How can you?
The reply is kindly turn to page 566. Answer 8.
By?
566.
Yes.
Making the same allegation, what he is advancing here, we also has made a representation, and that has been replied to under answer 8. 566. That as per clause 120.
From where you got you got the digital signature certificate?
Yes.
I do not find from this clause there is any stipulation of a certificate.
No,
The clause,
It should be digitally signed.
Yes.
What is the meaning of this? You have said uploaded all documents using a digital signature certificate.
Certificate. So
We have seen
Ah,
that uploading. One.
huh. From where you got the digital signature certificate?
as per clause 120, because
Yes, I am asking you, sir, where? And this clause is different.
the clause says it is to be signed, digitally signed.
So,
Certificate. So whether the digitally signature certificate is equivalent to this, that's our problem. Let's not take instruction with regard to that.
interesting.
That's because
A person may have a digital signature. The certificate is given by a particular the agency. Yes, this is your digital signature duly authenticated.
Yes.
But he never used the digital signature. What is the effect?
one,
Tell me, sir.
that I have to obtain instruction.
Obtain instruction.
And the signature is there. Your signature is there in all
Whatever.
papers.
Uh,
Item 7.
Please, my lord. It's a long-term value release method. 5 years for a maximum. Maximum. Period is 20 to 27, 5 years. Now he gets a show cause notice on 2012-1-2026, Annexure 10. Wherein, my lords?
Yes, who is for the other side?
Yes.
Permit him installment. He wanted an installment. It's a mercy petition.
If any order
It's a virtually a mercy petition.
And also I'm backed by Supreme Court that who can be
That
adjusted.
is Article 142.
Mother,
That's Article 142.
and also
Is a discretion.
Common Cause para 140.
Whatever is the discretion.
there is a
Can you give him 2 installment or a 3 installment?
Auspicious provision is there for filing appeal. Challenging the demand notice.
That's
If
fine.
he files
That's
appeal,
fine.
he has to declare.
Sir, he is not challenging a demand notice. Are you not understanding what he says? He says that whatever you have demanded, I have no grievance, I have no dispute. But give me some installments.
Fix of the installment.
Quarterly, 3 quarterly installments, I'll keep on doing.
Your lease is expiring when?
27. And 28. 28. 28. I have 2 more years of mining period available. And this quantity also can be adjusted for the next 2 years. Yes, it can be done. It can be done, the direct decision of the Supreme Court. Common cause judgment.
Yes, what you
Illegal
say?
extraction made by him. Illegal extraction has been made, therefore penalty has been imposed. Demand
You have not terminated the contract.
Yes.
Correct. Now this payment has to be made.
Payment has to be made, and if he agreed with that demand notice, then appeal
He
provision.
is not aggrieved.
No,
He is considering not aggrieved.
so let him deposit now 2 or 3 installments.
That is what we are saying, that 2, 3 installment, brother. 3 installment. Liberal.
Great. 2 months.
2 installments in within 3 months.
3
Within 3 months, 2 installments. 3 months. 3 installment monthly.
3
3.
well, by month. 2 months. At least I'll get some breathing space. Man. That is broken from November.
Don't bargain with the court.
No, I asked for this. Great. And the quantity, 6,000, that extra quantity will be adjusted over the balance 2 years.
What?
But that is permissible. I'll extract that much less. But I'll leave it. Great.
Item 7, disposal.
So I'm going to 3 quoted installments.
Yes.
Item 8.
This is Lord Jagannath's tender, which is now fallen into illegality and denial of level playing field. This is a case where they have announced, and just to draw an analogy for your lordship's convenience, announcing the spot for the test match and selecting a T20 player. That is the situation. If your lordship comes to page 25 of the application. That's page 25.
9.
Yes.
May I make this? The chief administrator so and so invites proposal for the interested bidders under single state cover envelope system technical resources for selection of agency for providing Lordship may take note of this. Comprehensive Facility Management Service (CFMS) for sanitation of Sri Jagannath Temple Puri premises. Now, your Lordship comes to the one serial numbers which are 1, 2, 3. This is one aspect. Second is they have not mentioned the estimated cost, which is as per the OPWD code and the CPT of the code, the estimated cost should be mentioned there. Now, your Lordship comes to.
Are they guided by any kind of a OPWD code?
My Lordship.
They have a separate, I think, the setup. They are all under the particular act.
Standard practices, estimated
That's
cost.
true. They are not guided by OPWD. Yeah?
The standard practices.
It is another issue, standard practice, but they are the different organizations.
You said that estimated part. I'm coming to the other aspect. The first aspect, which is the Comprehensive Facility Management (CFMS). The Lordship has
Where is that?
That is the heading, the tender under which they are floating this tender, my lord. So lordship sees the heading comprehensive facility.
I understand. Facility management
Yes.
services.
Your lordship comes to para 4 of my writ application. What is that? Your lordship sees, your lordship may start by the second subpara. CFMS provides a holistic approach to maintaining built environments by integrating hard surfaces, ventilation, so and so, plumbing, electrical, and shop cleaning, landscaping. These solutions ensure operational functionality, safe compliance, and cost effectiveness for commercial, residential, and industrial properties, often utilizing technology-driven monitoring and skilled on-site personnel. So what it includes a comprehensive category of works. So what they have done is they have put the heading there, but they have gone in for a sole sanitation purpose. So lordship, see, therefore CFMS is to eliminate the complexity of dealing with multiple vendors. Now, had they gone in for a multiple variety of works, CFMS heading would have been justified. But what they have done, they have given the heading the CFMS, but they have gone in for solely for sanitation only. Now, if your lordship comes to
No. For sanitation, only for the sanitation.
yes, that's what I'm saying. That
The temple premises.
mentioning of CFMS impliedly means that you are going for the entire thing which covers under CFMS, which have been indicated in the subpoena. They're not doing that. They've given the heading of CFMS, but that's what I do an analogy for your lordship's convenience, that they've announced that they'll be going for a test match squad and they're selecting T20 players. That's my analogy.
No. They are all the cricketers. They can play test match also, T20 also. There is no difficulty. There is no different categories.
So
that is not there.
My lord, so your lordship may come to that the pre-bid meeting was fixed to 7/4/2020.
What is the difficulty? Why you are going so technical on that aspect? Because this is a larger public cause.
Yes.
For sanitation has to be done, maintained.
Yes, my lord.
There cannot be any other aspect which is to be done. Why you are too technical on that? Participate. You have expertise in sanitation as well.
My lord, what they have done is they have fixed turnover clause at 10 crores, my lord.
Yes.
If your lordship feels
Because this is a use work which has to be done.
And I'm satisfied, lordship. Lordship,
Yes.
bear with me for a few minutes. Lordship comes to page 78. Lordship has 78.
Yes.
78 is the category of workers which are supposed to be employed by them. Now, if your lordship takes into consideration this number of workers which are there, then your lordship comes to page 107.
So financial bid has already been opened.
Yes, that's what I mentioned before. Your lordship yesterday when your lordship asked the audience of the mathematics.
Yes.
Your lordship comes to page 107.
No, 78 is a sweeper.
Yes, 78 indicates a table of the tender document, annexure 2, which lays down the number of manpower which is required as 115, 51 for Hither and total supervisors 4.
Correct.
So your lordship comes to page 107. I have
Yes.
demonstrated before your lordship that the estimated cost comes to 3 crores 80. 107. Annexure 6, my lordship.
There is no 10. Oh, this is a folded one.
Yes, yes, folded.
Okay. Yes.
This is the same number of workers which is under the table, which I have given the heading up and top.
Yes.
Annexure 2. And the estimated cost is right side bottom, your lordship will see 380. 3 crores 80. So as per the standard practice and procedure, they are supposed to be 30% of the estimated cost. Lordship sees, and I'll just draw your lordship's attention to my representation before them, which was submitted on 6/4 just before the pre-bid meeting, which is at annexure 3, my lords.
Yes.
Apart from the CFMS thing, which I have explained to your lordship, which the petitioner clearly laid out, that the usage of that term is incorrect since you are only going in for
Whatever. Yes. Whatever.
Thereafter, I gave submitted my
Page.
That is page 80. the lordship.
Yes. Yes. Yes.
Second point, financial capacity at the bottom, the lordship sees. RFP specified an average annual turnover of not less than rupees 10 crores in positive, net worth of rupees 5 crores, out of the estimated contract value is approximately rupees 4 crores per annum, which I have indicated to your lordship. As per CW approved guidelines, the turnover requirement should be around 30% of the estimated cost value. The current requirement is disproportionately high and is 500% of the contract value, which restricts fair participation. It is therefore requested to revise the turnover criteria within 1.2 crores. Now, to that effect, if your lordship comes to the next page, which I have given, page 83. This was with the letter, enclosed CPW memorandum, which is there with the letter.
Yes.
Your lordship sees serial number E1B.
Yes.
Requirement of average turnover modified from 50% to 30% of the estimated cost. Now
The difficulties, are they governed by all these kind of, the circulars, the rules which are made in this regard?
That they have to get an instruction because we.
Well, you issue a notice, come back next week.
Special messenger.
Next week. Special messenger you give. Next week. Monday.
4th May.
4th May is today. 4th May is Monday. Next Monday.
11th May.
Somebody was mentioning item number 21 that some officers are coming, are waiting. Who was mentioning?
My lord, I am there, my lord, in the virtual. Your lordships have already heard this matter. This is regarding that ongoing work. He was not disclosed, so that is why he was disqualified. That ongoing work that was mismatched, the lordship find page 101.
No, why the officers were called?
Officers called because their website uploading, your lordship will find page 101. Because we are the tendering authority.
So where are the officers? Why we have called?
They have been called because your lordship kindly see the order dated 24/26.
Mr. Manti, where are they? Where are they? Huh?
Where are they?
State officers. They are not
Superintending engineer, you lordship directed the state council.
Have they come?
Yesterday he was present.
Yesterday he was present. Your lordship said tomorrow is also for holiday. You can
Your
stay.
lordship directed me to submit the affidavit by giving the agreement copy, and when I have received the agreement,
I do not remember
I am
anything, sir.
filing the affidavit.
So please tell me
For
what
a,
is the.
my lord, for a moment, lordship will look at page 101. Page 101.
So you are sitting in a court's chamber.
Pardon?
You are sitting in your court's chamber.
Yes, in my chamber.
In my chamber in the court.
You have gone back to your residence.
Yes, I have come back to the residence because, my lord, in the Saturday, the habit is that to come back after lunch and to take the lunch at home. Today, that is exception. That is why I came, my lord. We are senior citizen and if your lordship, your lordship kindly see page 101. The date 6/2/25. Below table. First, second, third. Contract date is 6/2/25.
Yes.
Yes. Then your lordship kindly see that we received the letter from him, from the superintending engineer, that your lordship will find in the counter of OP number 2 and 3, that is page 8. They have said that date of agreement is 24/1/2025. The superintendent additional chief engineer from the office.
Yes, I think it was very short. Now I understand from the last order.
And then
I think ongoing work. Where is the officer?
and last date was
Where is the officer?
This matter is alerted Mr. Tripathi, his wife is ill, he shortly left for the hospital.
Let it be on Monday or Tuesday.
Because we need a clarification from him.
Your lordship, I have already heard the matter. Stay order.
Sir, it's the only question is, sir, please kindly consider, the only question is that whatever he has submitted, whether it is an ongoing or it is not an ongoing. If the execution is after the submission of the bid, then in that event it cannot be said to be ongoing. We just wanted a clarification. Come on Monday and give a clarification.
Lordship, kindly keep it in the
There's a second matter.
Second matter, oblige. Oblige.
So that we can release you before.
Because I filed a memo yesterday because showing the receipt of the advance service to the NSE because unfortunately it has not come up on your lordship's record today because I am handing over a copy of this report of the advance service to the Miller's copy of the writ petition to the NSE Miller. Here the NSE is a party plus and I have served them yesterday and I filed a memo Miller's in the registry, but it has not come up in your lordship's board today, Miller's, the records. Let me begin the lordship's because this present writ petition has been filed because challenging the cancellation of the tender. Because the initially tender was floated on 12th of February 2026, with the last date of submission was on 2nd of March 2026. On 2nd of March 2026, because they float a corrigendum extending the timeline Miller's up to 16th of up to 12th of March 2026. Thereafter, Miller's, the bid was opened, and on 28th of April 2026, Miller's, at morning 5:40 a.m., they cancelled the tender without assigning any reason. And in the cancellation order, Miller's, itself, it has been written that the tenders are re-invited, and on the same day they re-invite the tenders, Miller's. But initially, Miller's, there were 52 numbers of work, Miller's. Now in the fresh tender, there are 22 numbers of work. Because I have also given a comparative chart, Miller's, as to the corresponding numbers, Miller's. What are the serial numbers that were there in the earlier tender and what are the serial number in the fresh tender, Miller's. Exactly, Miller's. The eligibility criteria, the bid amount, everything is same, Miller's. There is no change in
So that has already expired in the fresh tender last date?
Is Monday, Miller's. Lordship may have page 51, Miller's, is a fresh tender. And the page 54, Miller's, the bid documents will be available in the website from 11 a.m.
Who is appearing in a notified area council?
In separate council minutes.
Who are they?
Notice may be issued to them.
Notice has been issued, but they are not coming up. Then in that event,
They are no panel. It is Dharamgarh NSE.
Yes,
They have to engage a lawyer. They may not be having panel.
Yes, Miller's. They don't have a panel. I have made them an advert service. Even I have contacted the executive officer, Miller's. I personally have called them and I have stated that this I have mailed you and you please confirm me. He confirmed me over the telephone, Miller's. The same I have put it in my memo also, Miller's. And thereafter, when this matter was listed today, Miller's, again I have called them and I have asked them that this particular matter is listed with so and so item numbers. Despite that also, Miller's, they are not here.
Are they appearing on virtual mode? Are they appearing?
nobody is appearing on a web.
Yes, notice goes to notice also
Yes, show us the judgments.
Miller's, one of the latest judgments by your lordship, the Maitri Infrastructure. Unfortunately, Miller's, I could get only one copy of this deal.
Which paragraph?
Maitri.
Miller's may have Miller's paragraph 11.5, Miller's, with regard to the reason your lordships have had. Miller's, abreast with the aforesaid principle, there is no escape than to hold that the chairman OMC is not justified in passing an order to cancel the tender in its entirety and issuing a direction to initiate fresh bidding process free from arbitrary and the respective eligibility condition, as this court exercising the power
of judicial review under Article 226 of the Constitution of India possess the tender notice dated so and so. Because exact same thing, that particular the facts are a bit different, but the ratio is this. If in case of an arbitrary cancellation, the same cannot be done, and your lordships may have the cancellation notice in this particular tender.
No, this is what issuing a direction for arbitrary and restrictive eligibility conditions. That is what we say, that you can't do it. That was a different issue. But where is a judgment which says that any cancellation, if no reason is given, it vitiates? Tell us.
Here we have called out certain official note saying they have.
The reason was that there was a restrictive clauses which were there, which was really making many participants out of the fray. So that is what we say. There is an arbitrary action that you cannot do it just to serve some of them.
You should call them.
In my repetition, they don't assign any reason.
Is there show us a judgment that the assignment of reason is sine qua non? Rather, we know just contrary judgment.
They have not highlighted the paragraph.
No, just show us a judgment that in every case when they cancel it without assigning any reason, they have to assign reason.
Here entire thing was over.
It was over everything.
Actual scenario was completely. I have.
Yes, it is your lordship.
Both have seen. We have.
It is your and they after opening the bid, they cancel it and they re-invite it. There is a predicament the financial bid was also opened. Now in the website, yes, in this case, the website now doesn't show because it is cancelled. In fact,
how you know that financial bid is open?
Because we get to know from the e-tender status. The bid was also opened. The bid was also opened.
So maybe a technical stage.
It's a single cover system, where upon opening of the bid, the financial bids also get open. I have submitted the same. I have made an amendment to that effect in my writ petition also.
My electric should go back and read SRB transport versus IOCL. Judgment passed by this Salonto. That's exactly on the point.
That is what I'm saying.
SRB transport versus IOCL. Justice Sarangina. That's a case tender. Cancelled without assigning a reason. Party is remitted back for this.
Our full bench decision is against that. Sri Ganesh is now held to be not good law by full bench. In this case, we have been cited.
He should by all those judgments.
By Mr. Sanjit Mahanti.
Come ready on 4th. You are not ready on 4th.
Sri Ganesh was declared. Along with that, another 2 judgments.
Subject of bidding the law. Otherwise,
what can you bring him? You have already given us bill. They have not come. Come show us on that ground. Otherwise, you can't.
Please see.
I'll go through.
Yes, call the next.
We have gone in other.
2 matters are already there. That matter.
Item 10. May I please? Sure. Kindly have a glance to page 129.
One.
The petitioner is a proprietary concern. The technical bid has been disqualified. Your lordship, page 129, annexure 4.
Where?
Serial number 1. Technical bid document verified with the original document as per tender guideline point 5.12
the bidders have not submitted the registration copy of the fire and all affidavits are not in proper format. I personally verified as per the tender document, all the affidavits are exactly said. It has been mentioned in the tender document, executive officer, stroke, the notary public. We have mentioned notary public because we have done here notary public.
Where is that?
That is at page 97 of the brief.
Yes. No, this is your affidavit. Where is the condition slash executive officer slash notary?
That is at page 60.
60?
68, my lord. Before the executive magistrate slash notary public. I have mentioned, since it has been done with the notary public, I have mentioned notary public.
Yes.
Therefore, all the affidavits are set. And since it is...
What is the registration copy of the...
It is a proprietorship concern and I have submitted the registration of made under the GST certificate that is at page 180.
Where is the condition? Where is the condition relating to registration?
In case of her, that is clause 5.2.
Page.
Clause 5.2 is at page. At page 32 of the brief. 5.2. In case the bidder is a firm company, copy of the registration certificate is issued by the competent.
No, I got it. So you are a proprietorship concern, so there is no question.
Whatever. Only on this ground.
Who is appearing?
Only one to pay. This is it. One to. Page 92.
Yes.
Page 92 is the petition of MS Unique Electricals. This is tender with regard to supply of manpower, laborers for loading and unloading purpose. The MS Unique Electricals, we have submitted.
What?
The tender with regard to supply of laborers.
Is 92.
Yes.
So what?
So we have submitted and under the Orissa under this act, all Orissa shops and commercial establishments Act 1956. So all proprietor concern or any other establishment has to be registered.
Registered where?
Registered for the competent authority.
Who is the competent authority for registration of a proprietorship concern?
All persons.
Show us that. I do not know, sir.
Yes.
Under the Partnership Act, I can understand the registrar of firms incorporates the name in the register. That's the registration I can understand.
Yes, the registration of all establishments.
But I am proprietorship, I do not know.
No, you are representing one. Two has floated. Civil Supply Corporation.
Yes, ma'am.
Yes.
They have floated.
Yes.
Sure. Where is
You
the
are hearing
registration?
for them. Civil Supply Corporation.
Okay, one. Yes.
Let him show. He's showing the law. He's considering. Yes. Show me that provision, sir, where it is.
Yes.
Local law.
These things.
The registration of establishment within the period specified in Sovereign Code, the employer of every establishment.
What?
The employer of every.
Employer.
Yes.
Okay.
Because under the
Anyhow, employer of every establishment.
The period specified in the subsection 4, the employer of every establishment shall send to the inspector of the area concerned a statement in the prescribed form, together with such fees as may be prescribed, containing the name of the employer and the manager, if any, the postal address of the establishment, the name and any of the establishment, the category of establishment, that whether it is a shop, commercial establishment, hotel, restaurant, cafe, boarding or eating house, theatre or place of public amusement, entertainment, and etc. Such other particulars as may be prescribed on receipt of the statement, and the fees and inspector shall on being satisfied about the correctness of the statement, register the establishment for the registered establishment in such manner as may be prescribed and shall issue the prescribed form in a form a registration certificate.
This is under what law?
It is under the Odisha Shops and Commercial Establishment Act 1956. So all establishment that has been defined also. What is the commercial establishment and what is the establishment?
Shop has been described under section 3.
This is what I was just heading towards that.
It is not a shop.
All establishment.
It is not applicable.
It says all establishment.
What is the definition of establishment?
That I am reading you. The establishment means shop or commercial establishment. Shop or commercial establishment.
That's the only definition.
That's the only definition. And what is commercial establishment? Means a commercial or trading or banking or insurance establishment, an establishment or administrative service in which the persons employed are mainly engaged in official work, hotel, restaurant, boarding, eating, house, cafe, and other refreshment houses, theaters, any other place, public amusement, entertainment, include such establishment as the state government may, by notification, declare to be a commercial establishment for the purpose so. So it covers all commercial establishments and establishments, and for that purpose it has to be registered. And registration certificate is being issued by the district level official. Here, the tender is for supply of laborers.
No, not supply of labor.
Some handling contractors.
Handling contractors.
Some laborers.
Page 16, labor works. Labor works.
Handling. Registration is establishment. But again, I'm asking if the clause is only restricted to a firm and a company, then how can you extend it to this? To a proper proprietorship concern? How can you extend it?
Well, this tender has been cancelled. The tender has been cancelled and re-tender has been made. 7th last date, he can apply.
You have disqualified me and invited for a test tender.
No, this not disqualified.
Yes, you read Annex 4.
Annex 4 I'm reading.
Yes,
No. Once he has disqualified, whatever be the reason, but you can participate in a fresh tender if they have decided.
If my bid is, the ground of disqualification is only this. I am challenging this.
Whatever we will say that it was not, since the new tender has already been floated, you are.
Recently protect the land that is insurance.
So you participate there.
My lord,
Is a technical bid stage, not a financial bid is open, so don't worry.
When my technical bid has been rejected,
we do not know whether these conditions have been calibrated or.
5.12, my lord, itself.
Oh, it has been calibrated in the new one. I do not know. In the new tender, we don't know.
My lord, in the new tender, the same conditions.
Same conditions. Then go and participate.
My lord, in view of 5.12.
Oh, we are making a clarification that it cannot stand in the way. You go and participate.
Then my lord, there is already one bidder qualified. My technical bid has been cancelled on this erroneous ground.
If there is only one bidder, they have cancelled. There is no difficulty because now you go and participate. We will simply make an observation that this cannot be done. Registration is restricted to only a firm and a company, which is not applicable to the proprietorship.
That view of the matter, this technical bid cancellation has to go, my lord.
But now the cancellation, whatever reason is, kindly visualize, they have taken a particular view, they have floated a new tender. Now the new tender is still there. The floating of the new tender was for the reason that there is only a single bidder.
The reason is,
Since you are disqualified, so there is a single bidder. Now you say, suppose if we set aside it, then there will be more than one bidder.
My lord.
But it will upset the whole thing, the exercise. So the equity demands, it's a equity demands that you are still entitled to participate, you can participate in that.
23rd of April,
No.
they cancelled this, and on 23rd April, they floated a new.
So now the 7th is the date you can participate with. We can only help you by making an observation that they cannot reject on this ground. That's all.
If this is the view of your lordship, then
It's a equity which is to be given. What you say, we are saying, it is an equity which is to be taken into consideration. It's only on the ground of equity, nothing more than that.
Well, on the same ground of equity, if I became eligible, my financial bid will be open along with the other. If I will
It's
get
too
it,
late. It's a too late in a day. It's a too late in a day.
otherwise the second one will get it. The second man.
We have to rely on the off-quoted judgments of the Supreme Court on that ground. Equity principles always there. Is for the larger public interest. Your right is not being taken away. Has it been taken away? After the financial bid is open, I can appreciate that you are put into some kind of a jeopardy, but it is not that. So once the financial bid is not open, you can definitely go and participate. Time is still there. No problem. You'll have to go there.
Your lordship set up the law, and in previous cases also where the fresh tender has been invited, your lordship protected them.
No.
Here in the same thing.
For another reason.
Technical ground.
For another reason. But
Two grounds
here is.
mentioned. One ground, I take your lordship, there is no error in the affidavit. Still then they have mentioned there is error in affidavit. One ground goes. The other ground is your farm is not registered. My farm is not required to be registered. I have filed a GST registration certificate at page 118.
So in other, we have stayed in other matters where there is a very strong cases of a probabilities, but it is the case which we find is technically weak.
My lord, your lordship have held in.
Then you don't because we have fixed the matter on 4th. So we may reject their application also.
No. I don't start
So we have not taken a view. We simply said that let them come. I think your time is still there because you are not really affected. But we can definitely say so that your eligibility becomes clear. That is what we can say.
My lord, the existing contractor who is there since last so many years, since his technical bid has been cancelled. Therefore, my bid has been cancelled.
No, this is not. This is not.
I have not taken that stand.
No, have you written it that this was the?
No,
So you can't argue something which is beyond the record. The equitable principles. We are not agreeing on this principle. Have you seen the commercial establishment?
Yes. Is it proper?
We are not agreeing. If you want, then we can say that it will not come under the purview of this.
Your lots of pages I have not put.
For the purpose of opposing it.
Yeah.
Labor.
The